This is a settlement hearing before the Indiana Utility Regulatory Commission and a cause docketed before the Commission as cause number 46183, captioned as Verified Petition of NIPSCO Generation LLC for certain determinations by the Commission with respect to its jurisdiction over petitioner's activities as a non-retail generator of electric power. Notice of the time and place of the hearing was given as provided by law by publication in Marion County in the Indianapolis Star on May 31st, 2025, in Lake County in the Northwest Indiana Times on June 2nd, 2025, also in Lake County in the Post-Tribune on May 30th, 2025. These are newspapers of general circulation, and these publications were made at least 10 days prior to the date of the settlement hearing. The proofs of publication of the notices have been received by the Commission and are now incorporated into the record of this cause by reference and placed in the official files of the Commission. Notice has also been given to the Indiana Office of Utility Consumer Counselor and other interested parties. May we have appearances, please?
Thank you, Your Honor. On behalf of both the petitioner, NIPSCO Generation LLC, and intervener Northern Indiana Public Service Company LLC, please accept the appearance of Brian Likens.
Thank you, Your Honor. Also on behalf of Northern Indiana Public Service Company Generation Co. LLC and Northern Indiana Public Service Company LLC, please accept the appearance of Lauren Aguilar from the law firm of Barnes & Thornburg LLP.
Good morning, Ron Gilbert, appearing on behalf of DX Hammond, JV, LLC, and I would ask the court to accept same.
Thank you, Your Honor. Please accept the appearance of Rob Hicks for the Steelworkers Union and Locals 12775 and 13796.
Thank you, Your Honor. On behalf of Citizens Action Coalition of Indiana, please accept the appearance of Jennifer Washburn, Robert Ragonen, and Samir Doshi. Mr. Ragonen and Mr. Doshi are appearing pro hoc vice. Thank you.
Good morning, Your Honor. Appearing on behalf of intervener LaPorte County Board of Commissioners, Shaw Friedman of the law firm of Friedman and Associates, LaPorte, Indiana.
Good morning. Please accept the appearance of Clayton C. Miller with Clayton Miller Law, PC, Indianapolis, Indiana, for intervener Clean Grid Alliance.
Good morning, Your Honor. Appearing on behalf of Tuckaneck Beckham LLC and Invenergy Renewables LLC, Nikki Schultz of the law firm Bose, McKinney & Evans, Indianapolis.
Good morning, Your Honor. Appearing on behalf of the NIPSCO Industrial Group, Joseph Rampala, and joining me today, Emily Vilsack of the law firm Lewis & Kappas, 1 American Square, Suite 2500, Indianapolis, Indiana.
Good morning, Your Honor. Appearing on behalf of the public, Adam Cashin and Jason Haas of the Indiana Office of Utility Consumer Counselor.
So there is a outstanding objection and motion to strike that was filed by GenCo and NIPSCO on April 14th. Having duly considered the motion, the reply, and the response, the objection is overruled and the motion is denied at this time. Mr. Likens, you may proceed.
Your Honor, this time we do not have any pre-filed evidence to admit. We'll be calling witnesses and offer their testimony at the time they're called.
Okay, thank you. Mr. Gilbert?
Yes, Your Honor, we would ask the court to accept direct testimony of David Pavlik, and I believe that's the only evidence we have to admit at this time. And it's pre-filed.
Okay, and that was marked as intervener DX Hammond Exhibit 1, correct?
Yes, Your Honor.
Okay, thank you. Any objections, Mr. Likens or Ms. Aguilar?
No objections, Your Honor.
No objections, Your Honor.
Thank you. Mr. Hicks?
No objection.
Ms. Washburn?
No objection.
Mr. Friedman?
No objection.
Mr. Miller?
Your Honor, our willingness not to object is based on a stipulation entered into by all the parties that we would be admitting DX Hammond's responses to data requests served by my client, and those will be part of the exhibits that I'll be offering when you get around to me. So subject to the introduction of those data responses, we have no objection.
No objection, Your Honor.
No objection, Your Honor.
And no objection, Your Honor.
Okay, thank you very much. Intervenor DX Hammond Exhibit 1 is admitted into the record of this cause. Anything further from DX Hammond, Mr. Gilbert?
No, Your Honor.
Thank you. Mr. Hicks?
The union is not submitting any evidence and does not intend to call any witnesses. Thank you.
Thank you. Ms. Washburn?
Thank you, Your Honor. Would you prefer that we go ahead and move into the record Mr. Thomas's testimony, or should we wait? I'll just move forward with CAC Exhibit 3, the stipulation.
Yes, please. Thank you.
Thank you, Your Honor. CAC would move for admission at this time what has been marked as CAC Exhibit 3, which is a stipulation between NIPSCO Industrial Group and CAC in lieu of cross-examination of the industrial group's witness, Gorman.
Any objections, Mr. Likens?
No objections, Your Honor.
Ms. Aguilar?
No objections, Your Honor. Thank you.
Mr. Gilbert?
No objections, Your Honor.
Mr. Hicks?
No objections, Your Honor.
Mr. Friedman?
No objection, Your Honor.
Mr. Miller?
No objection.
Ms. Schultz?
No objection.
Mr. Rampala?
No objection.
And Mr. Cashin?
No objection, Your Honor.
Intervenor CAC Exhibit 3 is admitted into the record of this cause. Mr. Freeman, do you have anything to enter at this time?
Your Honor, I may take a lead from Ms. Washburn. We're going to call Mr. O'Connell, and so I'll go ahead and seek to admit his exhibit, his testimony at that time, if we could.
Okay, thank you. Mr. Miller?
Thank you, Your Honor. Intervenor Clean Grid Alliance has one exhibit to offer as testimony. Exhibit 1.0 is the pre-filed verified testimony of Emily Piontek, which was predating the settlement in this cause. And then we also have Exhibit 3, which is the responses of DX Hammond to data requests served on that party.
Okay, and you said that was Intervenor Clean Grid Alliance Exhibit 1.0 and Exhibit 3?
That's correct, Your Honor, with the understanding that we will be offering 2.0 after Mr. Likens has offered the settlement testimony.
Okay, thank you. Any objections, Mr. Likens?
No, Your Honor.
Ms. Aguilar?
No objection, Your Honor.
Mr. Gilbert?
No objection, Your Honor.
Mr. Hicks?
No objection.
Ms. Washburn?
No objection.
Mr. Friedman?
Objection.
Ms. Schultz?
No objection.
Mr. Rampala?
No objection.
And Mr. Cashin?
No objection, Your Honor.
Intervenor Clean Grid Alliance Exhibits 1.0 and Exhibit 3 are admitted into the record of this cause. Ms. Schultz?
Thank you, Your Honor. At this time, Tuckaneck offers into evidence what has been marked as Intervenor Tuckaneck's Exhibit 1, the testimony of Kenneth Davies, Exhibit 1C, the confidential version of the testimony of Kenneth Davies, and Exhibit 2, the testimony of Kenneth Davies in opposition to settlement.
Any objections, Mr. Likens?
No objections, Your Honor.
Ms. Aguilar?
No objection, Your Honor.
Mr. Gilbert?
No objection, Your Honor.
Mr. Hicks?
No objection.
Ms. Washburn?
No objection.
Mr. Friedman?
No objection.
Mr. Miller?
No objection, Your Honor. I do have a point of clarification. I apologize. The exhibit that we offered into evidence as 1.0 for Clean Grid Alliance, as originally offered, had a public and a confidential version. We've worked with the petitioner, and it no longer needs to keep confidential the limited aspects of that. So we only offered the public version, and it now contains nothing redacted.
Okay,
So just to clarify that for the record, Your Honor.
thank you. And Mr. Rampala?
No objection.
Mr. Cashin?
No objection, Your Honor.
All right, Intervenor Tuckaneck Exhibits 1, 1C, and 2 are admitted into the record of this cause. Ms. Schultz?
Your Honor, Invenergy Renewables LLC has no evidence to offer. Thank you.
All right, and Mr. Rampala?
Thank you, Your Honor. At this time, the industrial group would enter into evidence the verified direct testimony of Michael P. Gorman, inclusive of attachment MPG-1. It would also offer industrial group exhibit 1S, which is the verified direct settlement testimony of Mr. Gorman.
So that was Exhibit 1S, and what was the other one marked as?
1, Your Honor.
Okay, thank you. Any objections, Mr. Likens?
No objections, Your Honor.
Ms. Aguilar?
No objection, Your Honor.
Mr. Gilbert?
No objection.
Mr. Hicks?
No objection.
Ms. Washburn?
No objection, Your Honor.
Mr. Friedman?
Objection.
Mr. Miller?
No objection.
Ms. Schultz?
No objection.
And Mr. Cashin?
No objection, Your Honor.
Thank you. Intervenor NIPSCO Industrial Group's Exhibits 1 and 1S are admitted into the record of this cause.
Thank you, Judge. Nothing further.
Thank you. Mr. Cashin, you may proceed.
Thank you, Your Honor. At this time, the public moves for the admission of the following exhibits. Public's Exhibit Number 1, the verified direct testimony of Brian R. Latham, pre-filed with the Commission on April 1st, 2025. And Public's Exhibit Number 2, the verified revised testimony of Michael W. Dupree, which was pre-filed with the Commission on June 13th, 2025.
All right. Any objections, Mr. Likens?
No objection, Your Honor.
Ms. Aguilar?
No objection, Your Honor. Thank you.
Mr. Gilbert?
No objection.
Mr. Hicks?
No objection.
Ms. Washburn?
No objection.
Mr. Friedman?
Objection.
Mr. Miller?
No objection.
Ms. Schultz?
No objection.
Mr. Rampala?
No objection.
Public's Exhibits 1 and 2 are admitted into the record of this cause.
Thank you, Your Honor.
All right, thank you. Mr. Likens, you may call your first witness.
Thank you, Your Honor. On behalf of intervenor NIPSCO, I would please call Chapo Napoi to the stand.
We'll go off the record. We're back on the record. Mr. Likens. Okay. Mr. Napoi, I'd like to swear you in at this time. Can you please raise your right hand? And you can stand as well, please. Thank you. Do you swear or affirm that the evidence that you will provide today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You may be seated. And you have the right idea with the microphone there. You need to speak very closely to it and slowly and clearly for our court reporter, please. Thank you. Mr. Likens, you may proceed.
Yes, thank you. Could you please state your name and by whom you're employed?
My name is Chapo Napoi. I am employed by NiSource.
And what is your title for NiSource?
My title is Vice President and Treasurer, Corporate Finance.
In that position, did you have prepared written testimony for this proceeding?
Yes, I did.
And do you have before you a copy of that testimony?
Yes, I do.
Do you recognize that testimony?
Yes, I do.
If I were to ask you the same questions that are in that written testimony today on the stand, would your answers be the same?
Yes.
And do you adopt that testimony as your sworn testimony today?
Yes, I do.
Your Honor, based on that from the witness, I would move for admission of intervenor NIPSCO's Exhibit Number 1, their verified cross-answering testimony of Mr. Chapo Napoi.
Any objections, Mr. Gilbert?
No objection.
Mr. Hicks?
No, Your Honor.
Ms. Washburn?
No, Your Honor.
Oh, thank you, Mr. Ragonen. Mr. Friedman?
No objection.
Mr. Miller?
No objection.
Ms. Schultz?
No objection.
Mr. Rampala?
No objection.
Mr. Cashin?
No objection, Your Honor.
Intervenor NIPSCO's Exhibit 1 is admitted into the record of this cause.
Thank you, Your Honor. The witness is now available for cross-examination.
Okay. Do you have any cross-examination, Mr. Gilbert?
None, Your Honor.
Mr. Hicks?
No, Your Honor.
Mr. Ragonen?
Yes, we do.
Okay, you may proceed.
Great. Good morning, Mr. Napoi. Did I pronounce that correctly?
That is close enough. Thank you.
Fair enough. Well, my name is Robert Ragonen. Feel free to butcher my last name as you see fit. And I'm representing the Citizens Action Coalition today. It is good to meet you.
Good to meet you.
I wanted to ask you some brief questions today on two topics. So first, I'd like to talk through NIPSCO's positions and commitments in this cause, specifically related to the financial risks associated with cost recovery and revenue-related issues. So first, is NIPSCO willing to commit to not seeking cost recovery for GenCo generation costs from non-megaload NIPSCO retail customers?
The purpose of my testimony was just to address the risks that NIPSCO may be a party to as part of GenCo. I am not here to make any commitments on behalf of NIPSCO.
That is fair. And to be clear, what I'm asking here is for you to clarify what NIPSCO's position is in this case. So I just wanted to then kind of point you to a specific part of your cross-answer testimony. If we could go to page 4. And then starting on line 13, you state that this concern can largely be addressed and mitigated by ensuring that the revenue NIPSCO recovers under a special contract with a megaload customer is priced at a level once NIPSCO pays GenCo under a separate power purchase agreement, PPA, provides GenCo sufficient revenue to cover its costs, including its financing costs. Do you see that here?
I do.
So in thinking about this statement that you made in your cross-answer testimony, is NIPSCO willing to commit to not seeking cost recovery for GenCo generation costs from non-megaload NIPSCO retail customers?
The purpose of my cross-answering testimony was to clarify how NIPSCO and GenCo may be able to mitigate the risk. I'm not here to make any additional commitments on behalf of NIPSCO.
So is that a no? You're not willing to make that commitment today?
The context, I'm just sticking to my pre-filed testimony. I'm not here to make additional commitments beyond the pre-filed testimony.
So I don't think that is an answer, Mr. Napoi. Is it a yes or a no?
Your Honor, I believe the question was asked and answered. I would note Mr. Paresi is being offered on behalf of both GenCo and NIPSCO. If that question is asked to Mr. Paresi, I believe he'll be able to give a full answer, whereas this was not part of the pre-filed testimony from Mr. Napoi. So I believe the question should be directed to Mr. Paresi.
Any response, Mr. Ragonen?
He can defer to Mr. Paresi if he would like to, but that is not what he is stating today.
Okay, I'm going to overrule the objection, but I will say, Mr. Napoi, please try to answer to the best of your ability, yes or no, or a more concise answer to that effect, if that's okay. Thank you. Mr. Ragonen, you may proceed.
So to be clear, Mr. Napoi, are you deferring to Mr. Paresi here, or are you just don't have an answer?
As it relates to commitments by NIPSCO, I am deferring to Mr. Paresi.
Okay. So at this time, then you're unable, it sounds like, able to make any commitments related to this case. Is that what I'm understanding?
I am deferring any NIPSCO commitments to Mr. Paresi. That is correct.
Okay. Well, I suppose that makes my list of questions a lot easier if you are unable to commit on NIPSCO's behalf. And just to, once again, clarify for the record, any commitments related to NIPSCO, you would defer to Mr. Paresi, correct?
That is correct.
Okay. Well, I'll go ahead and skip over a few questions here and move on to my next topic then. Let's talk about NIPSCO's role in this case. So make sure that we're on the same page here, under GenCo's proposal, NIPSCO would be GenCo's only customer, right?
That is my understanding.
And NIPSCO will be negotiating power purchase agreements with GenCo.
Your question is going beyond my pre-filed testimony, so I would defer that to Mr. Paresi.
Okay, so you're not familiar with the process that NIPSCO and GenCo will be undergoing?
While I am familiar with it, Mr. Paresi is the witness that could address your question.
Would it be helpful to, I just want to make sure that we're on the same page in regards to this process. Would it be helpful for us to look at Mr. Paresi's testimony in this cause?
Could you please clarify the question?
Yeah, would it be helpful if I refresh your recollection on the process with Mr. Paresi's testimony?
I would let Mr. Paresi address his own testimony. I am here to address my pre-filed testimony.
Well, we already went through a quote from your testimony where you discuss financial risks, right?
Could you repeat the question, please?
The portion of your testimony that we just went over together, where I read it aloud to you, do you recall that a couple seconds ago?
Yes.
That was in relation to financial risks, right? But your entire testimony, your cross-answer testimony, is related to financial risks, right?
Generally speaking, yes.
Okay. I'm glad we can agree on that. Let's start here. You agree that NIPSCO would provide service to the megaload customers, right?
Yes, that is my understanding.
And to provide this service, NIPSCO would negotiate special contracts with megaload customers, right?
Yes, that is my understanding.
Has NIPSCO begun negotiating a special retail contract with any potential megaload customers?
Your Honor, I'm going to object to the question. It's beyond the scope of his testimony. It's also beyond the scope of the proceeding with respect to NIPSCO's negotiations with customers. We're here about GenCo's application for a declination of jurisdiction.
Response, Mr. Ragonen?
Mr. Napoi has made very clear that his testimony is about the financial risks imposed on NIPSCO and its retail customers, and my questions are directly relevant to those risks.
Your Honor, there's a difference between a risk posed by a NIPSCO special contract with a end-user retail customer and a risk with respect to NIPSCO's relationship to GenCo. He is asking about the former, not the latter. The latter is what the proceeding is about, but this is not about NIPSCO's negotiations with current customers or potential customers for special contracts.
One last word, Mr. Ragonen?
Thank you, Your Honor. I think that this is precisely what is at issue in this case. We ought to be able to discuss with their representative and witness in regards to the potential risks posed by this whole setup. And to avoid the discussion with witnesses about these risks really does not allow us to have a full scope in terms of what is being proposed in this proceeding.
Okay, I'm going to overrule the objection, but I think it is a good reminder to keep it limited to the scope of the issue at hand in this proceeding. Thank you.
Thank you. May I re-ask the question, Your Honor?
Yes, please do. Thank you.
So, Mr. Napoi, has NIPSCO begun negotiating a special retail contract with any potential megaload customers?
It is my understanding that NIPSCO is in discussion with potential data center customers.
Do you recall how many of those megaload customers that NIPSCO is in discussion with?
Your Honor, I don't object to the question with respect to the scope. The answer to the question is likely confidential with respect to how many ongoing customer negotiations may be happening. So if we want to go in camera very briefly for a response to the extent it's inside of Mr. Napoi's knowledge, I do not know if it is or is not.
Okay. Is there a way you can ask the question, Mr. Ragonen, that would be sure to not elicit confidential information? If not, we'll go in camera.
Oh, no, I was under the impression that Mr. Miller had admitted an exhibit that is related to this question that is no longer confidential. Is that right, Mr. Miller?
I can certainly clarify that at the time we pre-filed our testimony on April 1st, we were referring to a response to a data request from March, which contained a number which at the time NIPSCO maintained was confidential. The ensuing months have resulted in that number no longer being confidential. That's the limits of what I can speak to in terms of this issue.
And for clarity, Mr. Miller spoke correctly. The point in time at which that occurred, we have no concerns with respect to that number being made public. With respect to ongoing negotiations, that would be a confidential matter.
Okay, I can move on. Appreciate the clarification, Mr. Miller. So how, Mr. Napoi, how will NIPSCO negotiate special contracts and PPAs?
I would defer that question to Mr. Paresi.
Now, I know that you stated that you're not at this juncture willing to make commitments in this cause, but is NIPSCO willing to commit to seeking to make its PPA payment obligation contingent on its megaload retail customers remaining at their original levels of demand?
I would defer that question to Mr. Paresi.
Your Honor, if we could briefly go into in-camera review, please.
All right, we'll go in camera.
CAC reserves the right to bring Mr. Napoi back to the stand.
Okay, thank you. Our in-camera review session has ended. And now we'll move to Mr. Friedman. Do you have any questions for Mr. Napoi? No questions, Your Honor. Mr. Miller?
No questions, Your Honor.
Ms. Schultz?
No questions, Your Honor.
Mr. Rampala?
No questions, Your Honor.
And Mr. Cashin?
No questions, Your Honor.
Okay. Thank you, Mr. Napoi. You may step down from the witness stand.
Thank you.
Unless, sorry, I misspoke. Mr. Likens, do you have redirect?
We do not have any redirect, Your Honor.
Okay, thank you. Now, Mr. Napoi, you may step down from the witness stand. Thank you very much. We'll go off the record. Mr. Likens, you may call your next witness.
Thank you, Your Honor. At this time, we would call Mr. Vince Paresi to the stand.
Mr. Paresi, I'd like to swear you in at this time. If you could please raise your right hand. Do you swear or affirm that the testimony you will provide today will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. And Mr. Likens, you may proceed.
Thank you, Your Honor. I will do my dead level best to keep everything clear, understanding that it's a little unusual to have a witness offering testimony on behalf of both a petitioner and an intervener. So I'll try to go in the right order and keep things clear, but if anything is not clear, please do let me know. Mr. Paresi, could you please state your name and by whom you are employed?
Vincent Paresi, Northern Indiana Public Service Company.
And you also have a position with NIPSCO Generation?
I do. I'm President and CEO for NIPSCO Generation LLC.
For this purpose, I'm only going to ask about your role as a president of GenCo, which is shorthand as I will refer to NIPSCO Generation LLC. In that role as president, did you have prepared petitioner's exhibit number 1, which was direct testimony pre-filed in this cause?
I did.
And was that testimony originally filed under another witness's name?
It was.
Before that was pre-filed in January, had you reviewed that testimony?
I had.
And are you adopting that testimony today as your sworn testimony?
Yes, I am.
With respect to petitioner's exhibit number 1R, do you see that before you on the witness stand?
I do.
And is this rebuttal testimony that you had prepared?
It is.
And again, with respect to other testimony in front of you, do you see petitioner's exhibit number 1RC, which should be in green?
I'm sorry, can you say that one again?
Petitioner's exhibit number 1RC. Might be labeled as confidential attachment 1RB at the top.
I do.
And is that a confidential attachment to your rebuttal testimony?
It is.
And then lastly, there's petitioner's exhibit number 2, which would be docket entry questions responding to questions from the commission. Do you see that there?
I do.
With respect to Petitioner's Exhibit Number 1, 1R, and then 1RC, if I were to ask you those questions in that testimony today on the stand, would your answers be the same?
They would.
And do you adopt Petitioner's Exhibit Number 1 and 1R, including attachments, as your sworn testimony today?
I do.
Your Honor, this time I would move for admission of Petitioner's Exhibit Number 1, 1R, 1RC, and Exhibit Number 2, and then I'll move to the joint exhibits.
Any objections, Mr. Gilbert?
No objection.
Mr. Hicks?
No objection.
Ms. Washburn?
No objection. Thank you, Your Honor.
Mr. Friedman?
Objection.
Mr. Miller?
I have one clarifying question, Your Honor. As the predicate to Mr. Paresi's testimony, he was identifying his different roles with NIPSCO and NIPSCO GenCo, and I may have misheard. Did Mr. Paresi indicate that he is the Chief Executive Officer of NIPSCO Generation LLC?
That's correct.
Not the Chief Operating Officer.
For NIPSCO GenCo. That's correct.
Thank you for that clarification. No objection.
No objection, Your Honor.
No objection, Your Honor.
No objection, Your Honor.
All right. Petitioners Exhibits 1, 1R, 1RC, and 2 are admitted into the record of this cause.
And now, Mr. Paresi, speaking to somewhat your dual role, do you see what's before you marked as Joint Exhibit Number 1S, which would be verified settlement testimony?
I do.
And did you have that testimony prepared on your behalf or under your supervision?
I did.
And then do you also see what's been marked as GenCo NIPSCO Joint Exhibit Number 1SR, which is settlement reply testimony?
I do.
And likewise, did you have that testimony prepared or was it done under your supervision and direction?
It was.
And if I asked you the questions that are in Exhibit Number 1S and Exhibit Number 1SR today on the stand, would your answers be the same?
They would.
And you would adopt Joint Exhibit Number 1S and Joint Exhibit Number 1SR as your sworn testimony today?
I do.
Your Honor, on behalf of GenCo and NIPSCO, I would offer Joint Exhibit Number 1S and Joint Exhibit Number 1SR, inclusive of all attachments, including the settlement agreement, as revised in Joint Exhibit 1SR for admission this morning.
Any objections, Mr. Gilbert?
No objection.
Mr. Hicks?
No objection.
Ms. Washburn?
No objection.
Mr. Friedman?
Objection.
Mr. Miller?
Thank you, Your Honor. Just another similar point of clarification. The reason I asked my question before is that looking, for example, at Exhibit 1SR, unless this has been corrected since it was filed, I see on line 3 of the first page, Mr. Paresi identifying his role as President and Chief Operating Officer for NIPSCO GenCo. And I'm just trying to understand if there's a different Chief Executive Officer or what the rules are, or if this is just a typo that needs to be corrected.
No, I apologize for both Northern Indiana Public Service Company and for NIPSCO GenCo. I carry the title President, Chief Operating Officer, and Chief Executive Officer.
Okay, so you are the President and Chief Operating Officer for both entities,
That's correct.
and the Chief Executive Officer for both entities.
That's correct.
Thank you for that clarification. I just note that the testimony only refers to the COO role, but with that clarification, I have no objection to the admission of this testimony.
Okay. Ms. Schultz?
No objection, Your Honor.
Mr. Rampala?
No objection.
Mr. Cashin?
No objection, Your Honor.
Joint Exhibits 1S and 1SR are admitted into the record of this cause.
Thank you, Your Honor. At this time, the witness is available for cross-examination.
Okay. Do we have cross-examination, Mr. Gilbert?
No, Your Honor.
Mr. Hicks?
No, Your Honor.
Ms. Washburn?
Yes, Your Honor. However, Mr. Friedman, we discussed and he said he would like to go first, which is absolutely fine with me. Just
Okay, Mr. Friedman, you may proceed.
Good morning, Mr. Paresi.
Good morning.
How are you today?
Well, thank you.
Good. Perhaps you can introduce yourselves to the commission and to the folks seated around here. How long have you been serving in the position as president for NIPSCO?
Just a bit over a year.
Okay. Are you aware the average tenure of a NIPSCO president the last 22 years has been about 2 years?
I'm not familiar with that statistic.
And congratulations on the promotion from Chief Operating Officer to CEO of GenCo. That must have just occurred.
I believe it's been in there. We're an operating company, and so we tend to use the Chief Operating Officer name.
You've indicated you've served in the position as president of NIPSCO about a year. Is that correct?
That's correct.
Where do you live currently?
In Indiana,
Okay, what county?
Lake County.
Is that your main residence?
It is.
Okay. So do you follow, for instance, publications, newspapers, indications in the service territory as part of your responsibilities?
I need more specificity, but at times.
Okay. And in terms of serving as president, as I indicated, the average tenure is about 2 years. Do you know, or have you endeavored to look at the history of NIPSCO in terms of some of the commitments that have been made, projects that have been promoted or proposed over the last 20 years?
I have not studied the last 20 years of NIPSCO.
Okay. If I told you you're the 9th president of NIPSCO since 2003, would that square with your knowledge?
It's not a stat that I know.
Okay.
We'll go off the record. And I just want to note, it is 10:46. We're planning to break at 11. I don't want to catch anyone by surprise. Just wanted to add that reminder. We're off the record. And when you're ready to go back on, I just want to make sure we catch you on the microphone here with your. We'll go back on the record.
Mr. Paresi, I've handed you what's been marked for purposes of identification as cross-examination Exhibit 1. Have you had an opportunity to take a look at that?
I have not. I'm not familiar with this document.
Okay. Take a look at it if you could, because I've got a couple names that I want to talk to you about.
I'm not familiar with this document. I did not prepare this document. I'm not prepared to speak to this document.
Okay, and I'm not seeking to introduce this. It's for demonstrative purposes. I'm asking you about the names on this. Do you recognize any of the names that are your predecessors as NIPSCO president?
Again, I'm not familiar with this document. I didn't prepare this document.
Okay, so you wouldn't quibble with my contention that the average tenure of a NIPSCO president's been about 2 years since 2023, would you?
As I've said, I don't have that statistic.
Okay. When you came in as NIPSCO president, did you endeavor to learn anything about past practices, past commitments, past proposals by the company?
I've spent a year at the company and certainly learning about the company.
Okay. Institutional history and knowledge of the company is important, isn't it?
Again, not prepared to speak to that question.
Okay. Well, you're proposing that this commission move on something that has, it's the first of its kind in the nation, isn't it?
I'm not familiar with this being anywhere else in the country.
Right. In your preparation for making this proposal to the commission, did you endeavor to find out if anyone, any other investor-owned utility in the country had proposed a new affiliate, a new largely unregulated affiliate, rather than repurposing an existing one for megaload customers?
We were attempting to find a creative way to meet a need in front of us and to do it in a way that would protect our base customers from that.
Okay. As part of this due diligence, did you attempt to survey what other utilities around the country have done to leverage existing unregulated affiliates for purposes like this?
We focused on the need in Indiana.
Okay. So there was no need to go outside to look at best practices, to study it in any way. Is that correct?
Again, focused on the need in Indiana.
What kind of a study was done before you brought this proposal forth?
Again, we focused on the opportunities in front of us, the desire to protect our base customers from the potential exposure, and to do it in a way that met the new customers' needs.
Okay. So you didn't go to school on what anybody else had done. Is that correct?
Again, we focused on the need in Indiana.
Okay. Did you survey what other investor-owned utilities in the state had done to deal with megaload customers?
At the time we created this approach, other utilities had not presented on what they were going to do.
Had you looked at what other states had done, other state utilities?
Doing in Indiana.
You felt you knew the best way without checking with any affiliates, without checking with any other investor-owned utilities, or even checking best practices in other states. Is that correct?
We looked at what was the best for our customers in Indiana and for our company, and for these new customers.
Isn't it true that I&M had proposed and settled 46097 by the time that you filed your petition?
I'm not 100% certain of the time frame, but I do believe it was out there at that point.
Okay. You've made the contention publicly, have you not, that the NIPSCO GenCo spinoff is in the public interest. Isn't that correct?
That's correct.
Okay. And that's been indicated in your testimony and also been publicly advertised as the intent, correct?
It's certainly in my testimony.
We'll go off the record. We'll go back on the record.
Yes, Mr. Paresi, as a resident of Lake County, you take or see the Times of Northwest Indiana?
I have seen the publication, yes.
Okay. And you recognize this particular article that ran after your testimony was filed?
I'm not familiar with this document.
You haven't seen the article that ran?
I'm not familiar with this document.
Okay. Are you familiar with news coverage that has occurred with regard to the GenCo case?
I am familiar with some.
Okay. Have you had a chance to take a look at the article?
Again, I did not prepare this document. I'm not familiar with this document.
Okay. Do you follow coverage as part of your preparation for hearings such as this so that you know what is being said in the public sphere?
I prepare my testimony and I look at those documents.
Head down, but don't look at anything like any kind of press coverage or anything like that. Is that correct?
Again, I prepare my documents.
Okay. Again, this is, from what we can tell, the first of its kind, unprecedented request by a utility in the country. You didn't think it was important to look anywhere else as to what others were doing before filing. Is that correct?
Again, we looked at what was important for Indiana and for our Indiana customers.
Okay. Did you generate an internal study to that effect?
Again, we reviewed what we believed would be important for our customers and for the large load customers.
Okay. Did it ever make itself into a written study internally?
I'm not sure I understand study what.
An evaluation, a primer, a narrative. This was the first time ever in the country that something like this was being requested. Who put the evaluation together inside the company for this?
NIPSCO GenCo was created to ring fence potential assets that would be needed for large load customers from our base customers. From our perspective, we were creating something to meet a need and to do it in a way that would protect our base customers from those costs.
Your Honor, I have no problem with the answer, but to the extent Mr. Friedman is trying to get into NIPSCO's regulatory strategy, which would be necessarily informed by attorney advice, mental impressions, and attorney-client privilege, I'm going to just note that we're going to object to that line of questioning. So just want to be careful that we're not getting into, for example, what regulatory strategy was developed or how that was developed and those sorts of things, which would be inappropriate.
I'm not seeking attorney-client privilege information. I'm trying to determine if there was some kind of a study done internally about the feasibility of setting up GenCo. If the witness doesn't know and doesn't believe, then he can indicate that.
To my understanding, an objection has not been made at this time.
That's correct.
Yes.
Right. Sir, was there any kind of internal study commissioned or performed by NIPSCO's staff on the feasibility of setting up a GenCo?
Again, we created GenCo to meet a need.
Sir, it's a yes or no. Was there a study commissioned internally by staff or not?
Again, we created GenCo based upon meeting a need.
Your Honor, could I ask Your Honor to direct a yes or no on was there a study commissioned internally or not?
So I will say that yes or no or I don't know, those are all very valid and acceptable answers. If you need clarification, you're always welcome to say, I don't understand, can you elaborate or rephrase? I'll also say that it's important that we keep things cordial. We just want to avoid any impression of, being not cordial. And I'll send that back to you, Mr. Friedman.
I couldn't agree more with the need for cordiality, and I thank you for that. I'm simply attempting to determine if there was an internal study. If not, fine. If this somehow magically appeared, then go ahead and say that.
Your Honor, at this point, I would object to the extent he's asking a question about, for example, whether a legal analysis was performed of other options and alternatives and the pros and cons by his counsel in preparation for a regulatory filing. That would be objectionable as it relates directly to regulatory strategy in preparing the filing that was submitted in January.
I'm not seeking any legal analysis by counsel. I'm not seeking anything privileged by counsel. What I'm asking the witness was there something prepared internally by staff at NIPSCO that led to the GenCo proposal?
It seems like there might be confusion around what a study involves. So I might ask if you could, maybe define that a bit more closely. And if I did that, Mr. Likens, would you maintain your objection or?
Depending on how the question is phrased, but potentially, I would remove my objection.
Okay, well, let's offer Mr. Friedman a chance to rephrase and see if we can continue.
Certainly. Not referencing anything that was performed by counsel. You've got numerous divisions within NIPSCO, accounting, engineering, marketing. Did any of those divisions propose or prepare some sort of study, evaluation, memoranda on the potential benefits of forming a GenCo?
In creating GenCo, we created it new. There was no study conducted to create GenCo.
Okay. And you made it clear you didn't consult other state regulatory agencies, you didn't look at other states, you didn't look at any one of your peers in the utility industry before doing this, correct?
In creating GenCo, that's correct.
Okay. In terms of knowledge of the regulatory environment in Indiana, do you have any knowledge of another largely unregulated utility subsidiary known as Pro Alliance?
I'm familiar with that name.
Okay. What do you know about Pro Alliance, or what do you recall about Pro Alliance?
Very little.
Okay. And just so that I understand, your career was mostly in Ohio. You're an Ohio State grad, went to work for an Ohio utility, and then came to Indiana as well?
Correct. I am an Ohio State grad, and I did work in Ohio for a lengthy time.
Okay.
I'll interrupt for a moment. When you're at a reasonable breaking point, we do need a break for our court reporters.
Certainly.
But I don't want to interrupt you if you're in the middle of a flow here.
I'll flow after the break, all right? Thank you, Your Honor.
All right, thank you, everyone. We're in a break for 15 minutes. We'll come back at 11:15. All right, it's 11:15. We'll go back on the record. Mr. Friedman.
Thank you, Your Honor. Mr. Paresi, just before the break, I had asked you about any knowledge of the Pro-Alliance case. You were involved in gas operations in Ohio, weren't you, for various companies?
That's correct.
Okay. And did you come to learn about the controversies surrounding the last time a utility had asked for a largely unregulated or a largely unregulated affiliate to be set up for energy purchases, specifically Pro-Alliance?
I believe you asked if I was familiar with Pro-Alliance, and I am familiar with the company. Not sure I understand the question from there.
All right. Do you remember what happened ultimately in the Pro-Alliance case?
Generally, I remember there were issues, but I didn't work for Pro-Alliance and wasn't involved in that case.
And you remember that Pro-Alliance was created to take control of Citizens Gas purchasing, transportation, and storage operations. Would that be?
That's beyond my knowledge.
Okay. You remember the controversy about the fact that with the two entities, it was the same people, same computers, same desks, same buildings for Pro-Alliance and the utility, and that was part of the controversy surrounding Pro-Alliance, wasn't it?
Again, I don't have that familiarity.
Do you remember that the utility, in fact, got the Utility Regulatory Commission on September 12, 1997 to approve the operations as being in the public interest?
Again, not familiar with that.
And if I told you that ultimately the entity was disbanded after a Supreme Court case ordering the breakup of that company, again, you don't have any recollection of that, do you?
Again, not familiar with that.
Okay. Now, again, as I try to probe for what helped inspire this proposal, we've gone down the study road. Did you consult the folks at Blackstone Capital in any way?
Again, in creating GenCo, we created that internally.
Okay, well, Blackstone Capital is now a 20% owner of NIPSCO, correct?
19.9.
I'll give you that, 19.9, that's correct, just shy of 20%. Blackstone has a history of establishing and managing unregulated energy subsidiaries, don't they?
Again, they're a 19.9% owner of NIPSCO. I'm familiar with that relationship.
Okay. They don't have experience that you could tap as well? Or did you choose not to?
Again, in creating GenCo,
Yes, sir.
we did that internally.
To my understanding, they control a $55 billion portfolio of active data center assets with an additional, sorry, you're right. I know. And 55 billion, thank you. Blackstone controls a $55 billion portfolio of active data center assets. Would that be consistent with your understanding of Blackstone?
I understand that Blackstone has affiliations with a data center developer, not certain of the size.
So in preparation for this proceeding, you chose not to consult any of the folks connected with Blackstone on how to set this particular subsidiary up. Is that correct?
Again, we created this internally. We did not consult externally.
Okay. Did you have any communication from Blackstone recommending or suggesting this as a particular path?
Again, we created this internally. We did not consult externally.
Okay, I understand you didn't consult. Was there any communication that you received from any of the representatives at Blackstone as this was being put together?
Not to my knowledge.
Okay. And in terms of first of its kind in the nation efforts, any familiarity at all with what one of your predecessors tried roughly 20 years ago on service center closings in the NIPSCO territory?
No familiarity with that.
And in attempting to adjust yourself to company history, there was no interest in learning anything about the service center case?
Again, I don't have familiarity with it.
Okay. Is there as you came on board, what kind of history of the company did you look at? Was it just the prior couple years, or had you gone back any further than that?
When I came on board, I focused on the things in front of us.
Okay. Well, one of the things that you were asked earlier was, who's going to make commitments? Who's going to make pledges for this company? And everything got deferred to you. You're the man in the hot seat at this point. Are you, and I'm asking you, and part of the concern was the short duration of NIPSCO presidents, any commitments that you make, you're committing to bind all your successors, is that correct?
Is your question that my commitments bind my successors?
Yes, sir.
Yeah, my commitments bind NIPSCO.
And your successors?
By committing NIPSCO, it would commit my successors.
Okay. Because if this thing all goes south within a year or two and you're not around to answer for it, and it's up to the commission to have to answer for it, it's going to be your successor that has to answer for it. Is that correct?
I have no plans of going anywhere.
Okay. Let's talk about the marketing of GenCo on Wall Street. Have you been involved in those calls with the analysts?
I have not.
Have you been made privy to the promotional material that's been supplied or that has been written about GenCo?
I think I'd need more specificity.
Sure, absolutely.
We'll go off the record. We'll go back on the record.
Mr. Paresi, I've shown you a document marked for purposes of identification as CX3. Do you recognize this particular report?
I'm not familiar with the document. I did not create this document.
I know you didn't create it, but you follow the trade press, don't you?
On occasion.
Well, do you follow reports, for instance, by Jeffries, the analyst on Wall Street?
Not specifically.
Okay. Who's been involved in communicating with Wall Street analysts about GenCo?
So NiSource communicates with Wall Street, our CFO typically, and his office.
Okay. Now, let me ask you about this particular document. It's dated October 29, 2024. You see that?
I see the date on the document, but again, not familiar with this document.
There's some indication by the analyst of Jeffries on page 2, Julian Demoulin-Smith. You see that name?
Again, not familiar with this document.
Sir, I know that. I'm simply asking about items contained in the document. Top of page 2, analyst Julian Demoulin-Smith. Have you ever spoken with her?
I don't believe
him?
so.
Is that correct?
I don't believe so.
Okay. Have you spoken to any analysts with any Wall Street firms about the plan for GenCo?
No, I haven't.
Okay. There's discussion about upside of $10 billion in upside capital spending potential from data centers and renewable build-outs. You see that?
I see those words, yes.
The analyst also cites favorable regulatory backdrops in Indiana, specifically citing 74% of revenue asks. That signals a favorable regulatory environment for your ambitious scaling. You see that reference?
Again, I see that sentence, yes.
You take exception to any of the content of this particular article?
Again, this is not my article. I did not create this. These are someone else's opinions.
Your Honor, I'm going to jump to the line of questioning. This is a document that doesn't have any quotes from the company, doesn't have any quotes from Mr. Paresi. It is an analyst's opinion, and the quotes are from an analyst. I'm not sure what the relevance of asking Mr. Paresi about this is when he has noted repeatedly he's not spoken with this man nor any analysts and doesn't have any information. So it sure seems that Mr. Friedman wants to testify about something as opposed to ask questions about the testimony Mr. Paresi is here to discuss.
I'm moving on to the next document, Your Honor, so he's indicated what he does or does not know. Let me ask a follow-up question that may deal with the objection, if I could.
Sure.
There is reference in the article to a return on equity that's anticipated by GenCo that's in this particular document. Do you take exception to the characterization that GenCo would generate healthy return on equity for investors?
Your Honor, I would object because I'm not seeing that reference anywhere in the document, but if Mr. Friedman could point us to it, that might be helpful.
Let's deal with a couple of the other documents that I'd like to have him testify to if he knows or not.
Okay, if we're moving on, we'll go off the record. We'll go back on the record.
Mr. Paresi, I've placed in front of you a document marked for purposes of identification as cross-examination 4, a Jeffries Equity Research Report dated February 13th of 2025. Do you recognize this?
I do not.
Okay. Do you get the NISource analyst reports in your capacity as president of NIPSCO or president of GenCo?
I do not.
You think it might be helpful to review these kind of things prior to proposing something of this size and precedential value?
Those are at a NISource level. I operate and manage NIPSCO and GenCo.
Okay. So you've not ever seen this report from the Jeffries analyst, is that correct?
That's correct.
Okay. Let me ask you about a couple of the characterizations and see if you take exception to them.
Your Honor, I'm going to reassert my objection earlier. This is obviously a report Mr. Paresi noted specifically he has never seen, he has no knowledge of. I don't believe him speaking to what some analyst or third party has to say about NISource generally is within the scope of his direct testimony or any of the testimony that he's offered today.
Your Honor, this GenCo has been sold on Wall Street as the best thing since sliced bread, going to make windfall returns for NISource investors. I think I've got a right to at least probe for this witness's knowledge of what GenCo is designed to do.
he is welcome to ask questions to Mr. Paresi about his knowledge of what GenCo is designed to do. That is very different than taking a third-party report that Mr. Paresi has never seen and attempting to cross-examine him and get him to agree or disagree with what some third-party analyst has to say about NiSource.
We'll go off the record for a moment. I'm going to sustain the objection, but I understand that let's go back on the record. Mr. Friedman, I'm going to sustain Mr. Likens' objections, but you, of course, may cross-examine the witness on those questions that you have. Thank you.
Fair enough. Thank you, Your Honor. Do you have any knowledge, Mr. Paresi, as CEO of GenCo, whether the risk-adjusted returns would favorably compare to traditional rate-based investments?
That I'm not familiar with that statement. I am familiar with GenCo and GenCo negotiations, as well as NIPSCO negotiations.
All right, but I'm asking about your knowledge of whether GenCo, as an entity, would provide for risk-adjusted returns that compare better to the traditional rate case return on equity.
I am familiar that we will be negotiating contracts with third parties if we're able to enter into an agreement that it will have a return. Our desire with respect to the return that it would be risk adjusted.
We'll go off the record. We'll go back on the record.
Thank you, Your Honor. Just to follow up on a statement you made a few seconds ago, you said we will be negotiating contracts with third parties, correct?
Correct.
Who is we?
NIPSCO.
Okay. So GenCo's return based on purchase power agreements with NIPSCO or with other parties?
Yeah, the way the structure would work is that, assuming approval of GenCo, there would be PPAs between GenCo and NIPSCO, and then contracts between NIPSCO and the customer.
I've got another document in front of you at the witness stand marked for purposes of identification as Cross-Exhibit 5. Have you seen this particular report from Jeffries, dated June 10th, 2025?
No, I'm not familiar with it.
So we've now established you're not following the analyst reports generally, correct?
Correct.
What publications do you ordinarily read?
My day is very full running NIPSCO.
I get it, but we all have to learn in our respective fields. We learn best practices. We learn what's out there. What do you gather, Mr. Paresi, to help assist you as you're making a consequential proposal like this. Are there trade publications that you routinely follow?
They're not.
None.
Nope.
Utility industry news,
No.
RTO reports.
No.
What other, I think I asked you about the Times Northwest Indiana. Are you a subscriber to any of the local publications?
I do get the Northwest Indiana Times.
Okay. Anything else? No other trade publications of any kind, is that correct?
That's correct.
Okay. You had a meeting recently, did you not, with the Republican Senate Majority Whip here in Indiana, Blake Dorio?
I have met with him, yes.
And it was specifically about issues in Elkhart County, wasn't it?
That was included in the conversation.
As I said, Senator Dorio is the Republican Senate Whip at the Indiana State Senate, and he expressed great concerns to you on at least 2 meetings, did he not, about NIPSCO rates, quality of service?
We have met a couple of times, that's correct.
Now, there were, and this was recently, wasn't it? April of 2025?
I believe we met in April, that's correct.
And I want to ask about who was present at these meetings. Senator Dorio said there were 3 different meetings. I think you were at 2 of the 3. Does that sound about right?
I believe I've met with Senator Dorio twice.
Okay. In the first meeting, sometime in March, he joined you and some other lawmakers to discuss issues. Is that correct?
That's correct.
The next meeting, he apparently joined the Secretary of Energy, Suzanne Jaworski, and a representative of the Utility Commission. You weren't at that particular meeting, correct?
I don't believe I was.
Okay. But there was a third meeting held Wednesday, April 16th that included Secretary Jaworski and others from her department. Is that right?
I don't have the specific date, but there was a meeting.
It says several members of the IURC. Were there any sitting members of the IURC?
Your Honor, Mr. Friedman's referring to it is talking about something. Could he clarify for the record what he's talking about or referring to?
Absolutely. There's a third meeting that was held Wednesday, April 16th that Mr. Paresi was at. And I'm asking who was at the meeting.
You said it says this. I'm asking
Yeah,
what you're
absolutely. I'm going to
referring
provide a document.
Okay.
Did you see?
Clarify what you're referring to, Mr. Friedman.
Thank you.
Because you're reading things into the record. We don't know if Mr. Parisi
Well,
has
he's
seen them. We're not sure
Excuse
what
me,
they are.
one moment, sorry. If you could direct objections to me and, speak through me, I'll speak to the parties.
I sure will, Your Honor.
So, did you want to ask what Mr. Friedman is referring to, what he's looking at and
That's
asking?
correct, Your Honor.
Okay. Mr. Friedman, are you able to share what you're looking at?
I am.
Okay.
Mr. Paresi is president of NIPSCO. Do you remember a news release that was issued by Senator Dorio on April 22nd?
I do remember a news release. I'm not sure of the date.
Okay.
We'll go off the record. We'll go back on the record.
Mr. Paresi, you do remember having seen this press release that Senator Dorio issued after your meeting with him, don't you?
I do.
Okay. And as I understand it, there was a meeting held Wednesday, April 16th. Secretary Jaworski, others from her department, members, you were there. It says several members from the IURC. Do you know who was there representing the IURC?
I believe the general counsel and one other staff member.
Okay. And this group discussed the problems that Senator Dorio had identified, both with poor service and rates, and the impact on business in his district. Isn't that correct?
We did have a discussion about his district specifically and some concerns.
Okay. Do you remember there being any discussion about problems in siting a proposed data center in Elkhart County?
I don't remember that topic specifically.
Okay. He indicated concern in this release issued April 22nd that rate costs and poor services have even caused some corporations to delay work or even move projects to Michigan. Do you remember him expressing that during your meeting?
I'm familiar with that from the article. I don't recall him expressing that specific issue in the meeting.
Your Honor, I'm going to move to admit Exhibit 6 at this time.
And was that intervener Laporte CX6?
Yes, thank you.
Okay. Mr. Likens?
Your Honor, I'm going to object. There's no relevance that's been established. In fact, Mr. Friedman asked if anything related to data center siting was discussed, and the answer was no. That's not discussed in the article. NIPSCO's services and rates in Elkhart County are not relevant to GenCo's application for declination of jurisdiction in this proceeding.
Your Honor, we're going to tie together the Elkhart County tie through Mr. Davies' testimony. I'm going to have significant questions about Tacanac Incorporated and the data center siting. The release and the meeting that Mr. Paresi was at specifically talked about economic development issues, business location issues. We believe it's relevant. He's identified having seen the document. We're asking for admission at this time.
Nothing further from me.
So I'll overrule that objection, but Mr. Likens' comment is noted that it needs to relate back to the question at hand in this proceeding. Thank you. Mr. Gilbert, do you have any objection?
No objections.
Mr. Hicks?
No objection.
Ms. Washburn?
Objection, Your Honor.
Mr. Miller?
No objection.
Ms. Schultz?
No objection.
Mr. Rumpala?
No objection, Your Honor.
Mr. Cashin?
No objection, Your Honor.
Intervenor Laporte CX6 is admitted into the record of this cause.
Your Honor, I'd like to have the direct testimony of Kenneth Davies, which has already been admitted in evidence, placed at the witness stand, if we could.
We'll go off the record. We'll go back on the record.
Let me direct your attention, if I could, to the direct testimony of Kenneth Davies, which has been placed at the witness stand.
Yes, it is.
You've had an opportunity in preparing your rebuttal and settlement testimony to review the testimony of Mr. Davies, haven't you?
Yes, I have.
One of the things I asked about earlier was attempting to consult with various people who are knowledgeable in data centers. Would you agree with me that Mr. Davies apparently has had over 20 years of experience in the data center and energy sectors?
I believe that's what his testimony says.
He was also a strategic advisor for the renewable energy arm of the Carlyle Group. Is that correct? Take a look at page 3, bottom.
That's what it says.
Also held leadership roles at Microsoft and Google, where he oversaw the renewable energy and portfolio management strategies for these companies. Is that correct?
It does say that.
And you don't have any questions about his experience or knowledge in this field, do you?
I don't know Mr. Davies other than from the testimony.
Okay. Middle of page 4, he talks about Tacanac in the final stages of raising a private equity investment and had been backed by a collective 9-figure investment from various venture capital investors. You see that? Lines 10 through 11.
I see that.
And again, you've got no basis as you sit here to question his credentials or experience in this particular field. Is that correct?
Again, I don't know him personally. I just have his testimony.
All right. Take a look at page 5, lines 13 through 15, where he opines that allowing NIPSCO to create an unregulated generation affiliate that competes with other generation providers when NIPSCO keeps a stranglehold on its monopoly service territory is not the answer. You see that reference?
I see that reference, yes.
You disagree with that?
I do.
Yeah. Specifically at the bottom of page 5, lines 19 through 22, he talks about data centers can bring tremendous opportunity for huge profits to utilities and the potential to increase load, which should benefit all customers. Is that right?
I see that statement.
And he talks about doing it through traditional rate making as opposed to profits siphoned off directly to NiSource as GenCo proposes in this cause. You see that?
I see that statement.
I take it you disagree with that.
I do.
Okay. Let's go to page 6. And just so that we're clear with the commission, Tacanac had a proposal for what's called Project Beckham, a data center in Elkhart County. Is that right?
I believe that's correct.
Okay. Specifically, Mr. Davies indicates at page 6, line 11, he wants to explain Tacanac's difficult experience with NIPSCO. You see that?
I see that statement, yes.
And he specifically indicates, in an effort to be of assistance to the commission, he's willing to share successful approaches from other states to the challenge of providing data center developers. He does that, doesn't he?
I see that statement.
So is it fair to say that Mr. Davies did in his testimony what you did not do, which was compare the proposal in GenCo to strategies used in other states?
I don't see anything in his testimony that would explain how he would protect base customers from the development.
Okay. He specifically talked about a difficult experience with NIPSCO, doesn't he?
Again, I see that statement.
Do you feel it was difficult for Tacanac to work with NIPSCO in citing its proposed data center for Elkhart County?
Your Honor, I'm going to object. This is part of the reason why we did file a motion to strike, which I understand has been overruled, and respect that ruling. But questions about testimony that's about a data center customer's interactions with NIPSCO to attempt to create a data center project is not relevant to GenCo's request for declination of jurisdiction. If this were a proceeding about a special contract between NIPSCO and Tacanac, that would be relevant, but it's not relevant in the context of this proceeding before the commission today.
I know NIPSCO can't stand Mr. Davies' testimony. They've sought to strike it. It's in, and it's been admitted. We're going to ask about the process. I'm not talking or asking about specific privileged items that were contained in any kind of privileged purchase agreement. I'm asking about the process, and that is absolutely relevant to the proceeding in front of us.
I'm not talking about confidentiality. I'm talking about the scope of this proceeding, which is not about NIPSCO's negotiations with any customer or experience of a particular customer with NIPSCO in attempting to bring a project to bear.
I'm going to sustain the objection, and if you could please try to tailor your questions going forward. Thank you.
Was there a refusal in this particular case to discuss interconnecting with the existing transmission line in Elkhart County?
My understanding was Taconoc's request was to connect to a PJM line. We are in MISO, not PJM.
Did NIPSCO insist that Taconoc pay for an interconnection study for a 15-mile dual 345 kilowatt line?
Your Honor, I'm going to repeat my objection. Again, he's getting into the details of a specific conversation between NIPSCO and a data center customer, not GenCo, and not GenCo's request in this proceeding.
Your Honor, this report is in evidence at this point. We've got this absurd wall that is set where Mr. Likens has to wear two hats, has to wear GenCo's hat, has to wear NIPSCO's hat. They're one and the same for purposes of this proceeding in terms of the discussions that are contained in Mr. Davies' testimony. The Davies testimony has been admitted. I won't belabor it, but I think it is fair and helpful for the commission to see what has occurred, particularly with Elkhart County, which I raised as part of Senator Dorio's press release, and why any change with GenCo or anything else would have no impact on that or would adversely impact the process. I think it's in the public interest to at least explore that, and I won't belabor it.
Your Honor, Mr. Davies' testimony is in the record in this proceeding. It speaks for itself. We've responded to the portions we believe needed responded to in Mr. Paresi's testimony already. So again, I believe it's improper to ask Mr. Paresi to read portions or agree with portions or those sorts of things. Again, it's already in the record.
We'll go off the record for a moment. Thanks for your patience. We'll go back on the record. I will sustain the objection. We're going beyond this specific question. I understand that there are public interest concerns, and I don't want to discourage you from asking questions towards that, Mr. Friedman.
Let me move on. NIPSCO has indicated in various discovery requests, as has GenCo, that no party has officially inked a deal with NIPSCO yet. Is that correct?
That's correct.
Now, Microsoft had publicly announced its intent to build a data center in LaPorte over a year ago. Is there a memorandum of understanding with Microsoft at this point?
Your Honor, I'm going to make the same objection. He's talking about specific discussions or negotiations between NIPSCO and a data center potential customer, not GenCo and not the request that's in this proceeding. I believe you've already sustained 2 objections to that effect, and I would ask to direct Mr. Friedman to please stick by those objections, or excuse me, by that ruling.
And Your Honor, who's Mr. Likens speaking for? Shouldn't he identify which client? Is it GenCo or is it NIPSCO he's speaking for when he makes the objection?
Okay, so do you have a response to this specific instance of the objection?
Who's it by? Is it NIPSCO or is it GenCo?
It's on behalf of both.
Okay.
Littered throughout the testimony is the indication that they've not inked a deal. I think I've got a right to probe in response to discovery requests what form that's taken of any kind.
So did you want to respond?
Yes, Your Honor, there are no specific customer negotiations discussed in any of NIPSCO's or GenCo's testimony in the proceeding, to the best of my knowledge. What folks may have asked about in discovery is obviously much broader than what is relevant for this proceeding that's before the commission at the moment. So what may have been asked in discovery is very different than what testimony. If Mr. Friedman would like to go directly to a piece of Mr. Paresi's testimony and ask him about that, that would obviously be within the scope, but negotiations with some other customer or a potential customer that NIPSCO has had, again, it just are not relevant to this proceeding.
Okay. So I'm again going to sustain the objection. We have testimony and evidence that we will weigh appropriately, and I understand you have questions, Mr. Friedman, but if they could be a little more narrowly tailored, or if you could point to specific instances, that would be helpful. Thank you.
Did Takanak express any interest in NIPSCO's rate 531 tariff, to your knowledge?
Your Honor, I'm going to again object for the same reason. He's asking about Takanak's negotiations with NIPSCO, which for the same reasons you just sustained an objection are not relevant.
Your Honor, it's in the record. It's now public in terms of the discussions with location. The Clean Gas Direct Attachment 1C is now public and specifically talks about projects that have submitted an intake form, inform NIPSCO of estimated location, project size, and ramp schedule. It is appropriate, I would suggest, based on what is already in the record, to talk about process and procedure.
Mr. Friedman is again citing to some testimony other than Mr. Paresi's about what I believe Clean Grid Alliance, who's he's referring to, may have referenced generally. I have no opinion as to what their testimony may or may not say, but he needs to go to Mr. Paresi's testimony and address what Mr. Paresi testified about or responded to. And again, he does not, to the best of my knowledge, in any testimony address specific customer negotiations, whether it be with someone who filed testimony in this proceeding, intervened in this proceeding, or did not.
There was no objection by NIPSCO or GenCo to the admission of GCA Direct Attachment 1C, which specifically talks about process. I'm trying to talk about process, Your Honor. And I won't belabor it, but I'd like to explore that, and then I will get on with other parts of his testimony.
Okay, thank you. The objection is sustained. If you could rephrase or ask a different way, please. Thanks.
Sir, your testimony references the need for speed to market. Could you please clarify what speed to market means in the context of this proceeding?
Is there a specific reference or just generally?
You've referred to it several times in your testimony. What do you mean by speed to market, and how does GenCo get you there?
Yeah, a number of large load customers that have approached us consistently have had a desire for quick load growth, both in sort of the initial connection with respect to our system, as well as the development of that load. It's different paces for different customers.
According to Ms. Whitehead's Petitioner Exhibit 1, which you've adopted, NIPSCO reported receiving more than 30 inquiries from potential new customers over the prior 12 months at the June 2024 IRP meeting. Is that correct?
That's correct.
When did NIPSCO management first become aware that data centers with demand of 50 megawatt or greater were interested in locating or expanding within NIPSCO's service territory?
The discussions have really been within the last year. Prior to that, there were some inquiries, certainly, that probably spanned about 6 months prior to that.
Now, you've had a chance to review Mr. Pavlak's direct testimony on behalf of DX Hammond, haven't you?
Yes, I have.
DX3 indicates they've required hundreds of megawatt. That planning has been in place for nearly 2 years. Is that correct?
Not to my knowledge.
Okay. Have they spent a considerable amount on engineering, feasibility, legal, and site planning, to your knowledge?
Again, all of our conversations with those customers are under NDAs. I need to be careful not to get into anything that isn't publicly out there.
Mr. Davies mentioned that NIPSCO was first approached in May of 2024 in his public testimony about serving Project Beckham data center site. Would that sound about right?
I believe we had a conversation in that time frame.
Ms. Whitehead, in her testimony, which you adopted, page 5, line 5, identified June 2023 as a cutoff for measuring the 30 inquiries. You remember seeing that?
I do.
Okay. Given the timeline of initial data center inquiries, would you agree that it has taken approximately a year and a half from first receiving megaload customer interest, June of 2023, to the filing of GenCo's petition in January of 2025?
I'm not sure I understand the question. Could you repeat?
There were initial data center inquiries. Would you agree that it has taken a year and a half from first receiving those inquiries in June of 2023 to the filing of the petition in this cause in January of 2025?
There were general inquiries in that time frame. Specific inquiries and specific discussions were much sooner, much more near term.
Your testimony, page 5, lines 5 through 7 states, given this very real interest, NIPSCO has developed a megaload strategy. The first step in that strategy is approval of our GenCo requested limited declination. Is that correct?
That's correct.
With 2 years having passed since the first data center inquiries, are you suggesting that NIPSCO has not yet taken the first step in its megaload strategy?
I would not agree with that.
You don't have approval yet, correct?
We don't.
Would you say that NIPSCO's failure to execute that first step of a megaload customer strategy over the past 2 years aligns with NIPSCO's emphasis on speed to market and the stated urgency of this petition?
Yeah, I would say that the pace of this case is paramount to us ultimately being able to meet the timelines of those specific customers that we're working with, which are very different than general inquiries that happened potentially a year and a half ago.
Well, in NIPSCO's service territory, the 22 counties, there hasn't been a shovel turned on a single project, has there?
We currently serve a data center, yes.
Well, that's the existing one from 2019, correct? The Hammond site?
That's correct.
But I'm saying in terms of new data center development, there hasn't been a shovel turned at any of these sites in the NIPSCO service territory, correct?
New data center developments beyond that one, that's correct.
Do you believe NIPSCO has acted in the public interest by not taking that first step in its megaload customer strategy?
I believe the first step of getting the GenCo declination approved is a critical step in that process to be able to protect our customers and move quickly when it comes to ultimately developing the generation.
Are you aware that other regulated utilities in Indiana have already completed full rate cases and have established transparent, publicly available tariffs for megaload type customers?
I am familiar with one other case.
And that would be I&M.
That's correct.
But you chose not to replicate or duplicate their strategy, is that correct?
I believe I&M strategy may work for I&M, but for us, we wanted to make sure that we were protecting our base customers from the costs associated with development of large load data centers.
You're not suggesting that the strategy employed by I&M, which was approved by this commission, somehow doesn't protect baseload customers, are you?
I was not part of any of the settlement negotiations with respect to I&M. I'm sure that it works for I&M, and I'm sure that it works in their scenario. We're trying to develop something that works for NIPSCO and our customers.
Well, but the approval by this commission in 46097 is public, isn't it?
It is.
And you know the guardrails that this commission insisted on in that particular proceeding, don't you?
I'm generally familiar, yes.
And you've looked at it and you don't feel it sufficiently protects baseload customers?
I think our GenCo strategy will more fully protect customers with respect to the cost of developing and ultimately the cost of operating those generation facilities and not putting those costs on them, and also creates opportunities for customers to benefit from it through payments for the system.
Remember, I asked you earlier in this proceeding, what did you do to study your peers in the industry to see what they were doing to accommodate megaload growth? You remember that?
I do.
You said, I haven't looked at anybody, correct?
I said in developing the data center strategy, we did that internally.
At what point in time did NIPSCO decide it would neither allow megaload customers onto existing tariffs nor create a new tariff for them?
NIPSCO doesn't have an existing tariff for large load customers. This has not been contemplated in our service territory and frankly even in the state until the last couple of years.
You don't think the 531 Tier 3 would allow that?
I do not.
Okay. But you didn't even attempt to apply to the commission or anybody else for authority to use 531 for megaload customers, did you?
I don't believe any of our rates currently serve that large customer load.
You're also aware that the legislature in its wisdom passed House Enrolled Act 1007, which provides another path to permit data center growth and development to go forward. Is that correct?
I am familiar with 1007, yes.
And again, you think you got a better idea than what the legislators did. Is that correct?
I believe 1007 is an option that could be used, but I believe our structure provides for more protection for our customers.
So you're saying that the option approved by the Indiana legislature, signed into law by the governor, does not provide the protection for baseload customers that your GenCo does. Is that correct?
I think it specifically allows for the use of 1007, but it doesn't require it.
Did you not file a rate case, specifically 46120, after you had the IRP in June of 2024?
We did have a rate case, an electric rate case in 2024. That's correct.
And yet you did not seek any authority from this commission as part of the rate case for a specific megaload tariff, correct?
That's correct. We did not ask for that.
Again, how does that help speed the market by not choosing to get that tariff during the course of your rate case?
Again, that presumes that at that time we had knowledge of the level of and specific customers that we're working with today.
Your June 2024 IRP makes very clear to this commission about the data center interest and prospective load, does it not?
And if you'll recall, during our IRP process, we actually modified the approach after the first meeting because we were starting to see an increase in those requests.
Sir, wouldn't creating a new tariff or amending an existing tariff under the traditional regulatory process result in more certainty, transparency, and ultimately increased speed to market?
I don't believe it would I don't believe it would increase speed to market, and I certainly don't believe it would protect our customers the way the GenCo approach would.
And again, when you say it won't do what I'm saying it won't do, you've got no study, no evaluation, no industry report to base that on, do you?
We have the experience of our current tariffs. We have the experience of our current customers. We put new customers on our system all the time. We file CPCNs that take 240-plus days to ultimately get through, and we understand how all of those processes work. So I do think we are drawing on existing experience in creating the GenCo approach.
Just want to note it's 12:10. We have a planned break at 12:30.
Your Honor, could I ask Mr. Freeman to clarify if he's asking a question on behalf of LaPorte or the CAC?
Huh?
I was wondering if you're asking the judge if she could ask you to clarify if you're asking questions on behalf of the CAC or LaPorte.
Now, that's snarky, Mr. Likens, and doesn't become you. It is on behalf of LaPorte County. Your Honor, I don't have that much more. If it would be helpful to take the break at this time, or would you prefer that I motor on and try to?
Let's go off the record for a moment.
If you'll allow me just a minute or two, I may be able to finish up shortly.
Okay, we'll go back on the record.
Yes, just a break so that I can determine what else I've got.
We'll go off the record.
Your Honor, I did want to note, I identified this for Mr. Likens, that last night we identified about 9 reference errors in the attachment A to the settlement. I don't know when we want to address that and make sure everybody has the correct information in attachment A to the revised settlement attached to Mr. Paresi's settlement reply. But I did want to flag that might be something that will take hopefully a short order, but there are about 9 errors in the attachment A. Oh, sure. I'm sorry. I thought it was attached to Mr. Paresi's reply, settlement reply. I didn't know if that was already part of, so I assume that was already part of the record.
It has been offered as an attachment to the settlement reply testimony. Happy to clarify those and did check and agree there's some references to Section A versus Section B that are typos that we can correct.
Okay, so we'll have a correct copy and evidence today.
We will get it submitted to you before close of business today. We just became aware of that this morning, and we appreciate CAC pointing those out for us.
Oh, okay.
Yep. And if it's possible to make sure we file it, pre-file it or file it on the portal, or just make sure that the correct copy is out there just for reference, if that's all right. Thank you.
Your Honor, one other housekeeping detail. I was waiting to offer Clean Grid Exhibit 2, which is our response to the settlement testimony. I can do that at any time to fill 30 seconds.
You okay with that, Mr. Friedman? Okay. So, yeah, let's go on the record and do that, and then I'll check with you, Mr. Friedman, and if you're still ready to take a break, we'll do that, okay? We're back on the record. Mr. Miller.
Thank you, Your Honor. Just to complete the evidentiary record submitted on behalf of Clean Grid Alliance, we now offer our Exhibit 2 into the record, which is the verified testimony of our witness, Emily Piontek, on behalf of Clean Grid in response to NIPSCO and NIPSCO GenCo's settlement with the NIPSCO Industrial Group.
Any objections to Intervenor Clean Grid Alliance's Exhibit 2? Mr. Likens.
No objections, Your Honor.
All right, Mr. Gilbert,
No objections, Your Honor.
Mr. Hicks,
No objection.
Ms. Washburn,
No objection, Your Honor.
Mr. Friedman,
Objection.
Ms. Schultz,
No objection.
Mr. Rampala,
No objection, Your Honor.
Mr. Cashin.
No objection, Your Honor.
Intervenor Clean Grid Alliance Exhibit 2 is admitted into the record of this cause. We'll go off the record. We'll go back on the record. It is now 12:15. We are going to take a break for lunch. We'll reconvene at 1:30. Thanks. We're off the record. We have a planned break for 3 p.m. That'll be a 15-minute break. Okay? Mr. Friedman, if you'd like to proceed.
Thank you, Your Honor. LaPorte County is prepared to pass the witness.
Okay, thank you. Ms. Washburn.
Thank you, Your Honor. Good afternoon, Mr. Paresi.
Good afternoon.
Thank you for being here. I know it's a long day and it's a hot seat up there, so thank you. So as we covered before, you are president of both NIPSCO and GenCo, as well as CEO, correct? And COO.
That's correct.
Okay. And could you please remind us when you were appointed to be president of GenCo?
I believe it was with formation in November when it was created.
And I believe I read that Ms. Shikani and Melody Birch Birmingham are also managers of GenCo, is that correct?
That's correct.
And what is your role in relation to those two individuals?
Jennifer Shikani is on our, works with NISource and is on our regulatory team as vice president, and Melody Birmingham is my boss. So she's president of the utility presidents.
And so in the context of GenCo, how does she fit? What are their roles? What do they do in GenCo?
I would say no daily roles. I believe it's an LLC, so I believe they're the members, the managing folks.
Okay. Are there others that are part of GenCo at this point?
Not currently.
Okay. And we covered this a bit, but I just want to make sure I'm, were you involved in the decision to create GenCo?
I was.
Who else was involved in that decision?
There was a team of several of us directly involved. There were probably 2 other people.
And who were those?
Michael Loers, who is an EVP with NISource, and Dan Douglas, who is an SVP with NISource.
How many hours per week have you spent in your role as president, CEO, and COO of GenCo?
I mean, it fluctuates week to week, but there's typically 15 to 20 hours a week.
Do you expect to remain GenCo president, COO, and CEO for the long term?
That could change as, approvals happen, hopefully, and it starts to operate. We could put someone else into that seat.
Do you have any plans for that as of now?
No plans.
And I believe we also covered this, but if you could remind me, you also expect to continue serving as NIPSCO president and leadership for the long term?
That's correct.
Have you created a strategic plan for GenCo?
We have not.
Hopefully this is helpful. We pre-marked a bunch of cross exhibits. If we may go off the record, and I can make sure that the witness has the stack.
We're off the record.
Thank you. Thank you. Sure. Got it. Thank you.
We'll go back on the record.
Thank you. The first document in this stack, and we'll just go one by one as I progress through my planned cross. But this first document is NIPSCO's response to CAC request 1-007. Do you see that?
I do.
Okay. And before I get there, how will you ensure an arm's length negotiation between GenCo and NIPSCO if you're the head of both companies?
Currently, there have been no negotiations between NIPSCO and GenCo. That would occur In the event we sign a special contract, we would ultimately need a PPA between NIPSCO and GenCo. So at that time, we would have that negotiation.
But how will you maintain the arm's length negotiation? How do you get over the conflict of interest between the two companies?
Yeah, we would certainly have counsel working on both sides, and potentially, like I said, may have someone else with respect to GenCo in that leadership position. If not, then we'll have to ensure that we have multiple people, not just me, involved in that discussion.
Is the plan to move so that you have separate humans, separate individuals at each company?
Potentially. We don't have a plan for that right now.
As the president, COO, and CEO of both companies, what do you think? Should you have separate individuals at both companies?
Potentially. It's certainly an option, to your point, to ensure separation between the two entities in a negotiation. It's certainly a way of managing that. Another way would be for me to be in both seats and just to ensure that we have other folks, other people at the company reviewing both sides of the transaction to ensure we've got arm's length negotiation. In any event, the PPA would go in front of the commission for review.
But how would you negotiate with yourself? You understand the concern from the consumer party perspective.
Assuming we're able to get to a special contract, the special contract is going to ultimately drive, for the most part, what the generation capacity and assets are that are needed for NIPSCO to serve that customer. So that will drive the PPA more than anything else.
But again, going back to keeping a GenCo hat on and a NIPSCO hat, how do you have that Chinese firewall, for lack of a better term, when you're negotiating big dollar deals like this?
Yeah, again, we'll have other people involved besides just me with respect to any kind of a negotiation with respect to GenCo and NIPSCO. But certainly one way of managing that would be to put someone else in charge of that organization.
Can you commit today that you would have separate individuals representing GenCo and NIPSCO? So separate individuals from GenCo and NIPSCO. Can you commit to that today as leadership of both?
Yeah, as I said, we don't have a plan for that right now, so I'm certainly not prepared to commit to do that today. But it's certainly something that when we present a PPA to the commission for approval, we can certainly have that conversation at that time.
But that's the crux of this case, right? This structure, this procedure, this process that GenCo has put forward that is to say we're going to kick the can down the road to decide all of the details, right?
The GenCo structure certainly is in front of the commission at this time for review and approval.
But we don't have any details, for example, with having separate individuals negotiating, one on behalf of NIPSCO and one on behalf of GenCo.
And again, I don't think that's critical for purposes of understanding whether or not GenCo will be an operating company going forward. I think it's important to get that piece in place that will help us then build the rest of the pieces that we need to ultimately facilitate the overall strategy.
Are the data center interests aligned with your retail ratepayer interests when you're walking into this negotiation, these negotiations?
I'm not sure I understand the question.
What I'm trying to get at is how can you be a representative of both your retail ratepayers and data centers? How can you align those two interests with one another when you're going through these negotiations?
This structure ensures that any generation capacity assets that ultimately we would need to serve large load customers would be separate, ring-fenced from our traditional customers. I don't know that there's a better way to ensure that I'm representing both the interests of our core customers and the interest of the new customers than to separate those assets.
But we don't have a plan to pass along the benefits back to retail customers, right?
Again, that would be part of a special contract negotiation.
But part of the declination statute is that you are acting in the best interest of customers, right?
That's correct.
So how do we make these decisions without any details?
Again, I think it's critical to first understand whether or not GenCo is going to be an approved structure. From there, we can negotiate and hopefully finalize contracts between us and counterparties that would then be put in front of the commission for review and hopeful approval, but we get everyone the opportunity that would like to be part of that process, an opportunity to be part of that process.
But wouldn't you say it's the commission's job here to ensure that we're looking ahead and mitigating risk before we give a carte blanche sign off on something like this?
I think that's exactly what this does. This creates a structure to ring fence significant assets from our base customers and insulates them from the costs of operating and building those assets.
But we have no details, right?
Those details will be provided in a special contract.
Looking at CX3. Going down here to the response. So we have a question here about will NIPSCO collaborate with GenCo to determine GenCo's targeted rate of return on invested equity capital? That's part A. And then part B is, will NIPSCO collaborate with its owner or ultimate owner to determine the targeted rate of return on invested equity capital for NIPSCO GenCo? Do you see that?
I do.
Then down at the bottom, we have management of GenCo will determine NIPSCO GenCo's targeted rate of return. Do you see that? The third line down in the response.
I do.
How will you determine the rate of return in that relationship with NIPSCO's retail ratepayers?
The rate of return with respect to a special contract will be part of the negotiation between us and the counterparty.
So there is no plan to pass along benefits back to retail customers, only a plan for risks to be assigned to retail customers?
No, in fact, I think we had this both in the testimony as well as some discovery responses, but any third party that's utilizing our system will have to pay for use of that system. All of those benefits will go back to our base customers, and depending on the size of the load, could be significant.
But we don't have a plan yet, right?
Again, that'll be part of the negotiation.
As GenCo president, have you talked to banks or other sources of financing for power construction?
I have not.
Have you talked to NiSource management or ownership about their plans to contribute equity capital for GenCo's activities?
We have not talked about equity investment at this point.
Have you talked to data center developers in your capacity as NIPSCO president?
Spoken with multiple counterparties with respect to large load development, yes.
Have you begun negotiating a retail special contract with any potential megaload customers?
We are in the process of negotiating contracts with several counterparties.
There was a data request response attached to Clean Grid Alliance's testimony that has now been made public. And I can bring you a copy if you'd like to see it, but otherwise I'll read it to you. It says NIPSCO has approximately 8 data center or mega load projects that are currently active in its service territory. Has that number changed?
I believe that was, it was correct at the time. The number is different today.
Can you tell us if it's, I think the last time I might have seen you was at that June IRP meeting. Do you recall that?
I believe that's correct. We may have seen each other since then.
That's possible. And at that meeting, that was when we heard the announcement about the data center load, right? Is that right?
That's correct.
Okay. And in that presentation, it mentioned that there were 2 to 3 data centers that you were in conversation with, and then it changed to 6. You recall that?
I recall we've been in conversations with multiple different counterparties.
Okay. And that was all public information, right?
If it was in the process of the IRP, it would have been public.
Okay. So we knew in the IRP process that it was 2 to 3 or 6. We know from about March or April that it was about 8. What is the number now?
I cannot give you a specific number. All of our conversations that are ongoing are subject to non-disclosure agreements, and so I don't think I should give you a number.
I'm not asking for who they are, just what is the number of data centers that NIPSCO is planning for?
At this time, we have multiple conversations happening. Planning for it's going to be dependent upon whether or not we ultimately sign a special contract and that is approved through the process. So at this point, we just have multiple conversations and negotiations occurring.
With how many entities?
Your Honor, the answer to this question is likely, or is, yeah, the answer to this question is confidential, so to the extent Mr. Paresi does know and have a number, the answer would be confidential.
Your Honor, I don't see how it was not confidential in June. It wasn't confidential now in March, but it's just the number of data centers. We have that information from the utilities. There's no proprietary or trade secret or other types of information for which they can claim confidentiality. I don't understand why that would be marked as confidential.
Specifically, I think those that may be trading in our stock or those that have an interest may want to know an exact number. If the number is small, they may think there is more interest, or excuse me, less interest than they expected. If the number is large, they may think that there is more interest in more potential megawatts. I do believe the answer to the question could have a potential impact on those that would like to trade in our stock, and that's specifically why we're seeking confidentiality.
And again, why was that okay in June 2024?
Your Honor, you can make public disclosures at certain times. When you make public disclosures, you do those in public filings, such as 10Ks, 10Qs, et cetera. If we make a public disclosure, information then becomes public. We have not disclosed currently who we are negotiating with or how many of those negotiations are ongoing. If, for example, that became public in an earnings release or something like that, that is a true public release, not public information in the sense of a public testimony or in a newspaper, that is very distinct from where we may be sitting at this exact moment in time with a specific number of counterparties. I don't understand why Ms. Washburn needs that to be public. We're okay with providing that answer, but would like it to be confidential, again, based on the potential materiality, especially with respect to those who may want to have that information and know how many, because it could be impactful to our stock and those sorts of things.
Okay, we'll go off the record for a moment. We could go in camera and discuss it.
That is just fine, Your Honor.
Okay. So is that agreeable, Ms. Washburn?
I would like to stay in the public session. If I can even just get an indication, I mean, I guess we can, to get an exact number, maybe we need to, but what I'm trying to establish, and Mr. Likens did say as such in terms of the impact to NIPSCO's profitability, but there are a lot of moving numbers here that are constantly changing, and the public deserves to know what's going on. If that's what the commission would like to do, but I would like to note my objection. I think this is public information.
All right, we will go in camera. Anyone who's not, oh, we're back on the record, sorry. We will go in camera for a moment. Anyone who's not subject to confidentiality agreements, now is the time to step out. Our in-camera session has ended, and Ms. Washburn, you may proceed.
Thank you. Pivoting for a minute, back in June, the standard by which NIPSCO was quantifying data center developer interest was whether or not NIPSCO had a signed non-disclosure agreement with the data center. Do you recall that?
I recall we did need to develop a process to ultimately take in the requests.
And now we do have this data center intake form and some other criteria by which the, I guess going back to the Clean Grid Alliance attachment 1C of the direct testimony, I'll just read it to you, but if you'd like a copy, I can bring it to you. It says, by active, NIPSCO means the projects generally have submitted an intake form, informed NIPSCO of estimated location, project size, and ramp schedule, paid for formal engineering study, and are in active discussion with NIPSCO. Is that still the same?
I think that's a fair characterization. I would say there's probably an additional piece to that when it just comes to more active negotiations with respect to a contract, a special agreement.
So you have moved forward and are negotiating. What stages are you in terms of finalizing contracts?
We're in various stages.
Close to signature on any of them?
Your Honor, I'm going to object at this point. Again, much like the questions Mr. Friedman was asking, specific negotiations between NIPSCO and any customer, whether named or unnamed, are not relevant to the declination of jurisdiction proceeding. Whether we may be close to a signature, whether we may be in the first turn of a draft or wherever it might be, it is not relevant. To the extent the objection were overruled, it would absolutely be confidential and would actually be more material and more highly sensitive than the number of data centers with whom we may be negotiating.
Your Honor, I can withdraw my question. However, I would strongly object on the relevancy grounds, but I don't need to know exactly where we're at, but I just want to note for the record that this is highly relevant. Thanks. Have you talked to data center developers in your capacity as GenCo president?
I have.
How has that differed from your discussions as NIPSCO president?
The most conversations have happened between NIPSCO and the developers, given those special agreements, special contracts will be between NIPSCO and GenCo. There are times where we're getting more specifically into the generation, and in that capacity, I would talk based upon that.
How is GenCo getting funds to pay its bills currently, such as legal costs, expert consulting, salaries? Who's paying for that?
Yeah, GenCo is a subsidiary of NIPSCO Holdings too, so funding is at that level at this point.
Could you please look at the next cross exhibit? And to clarify, is the funding coming from NIPSCO O&M at all?
It is not.
And would you agree that this sounds like equity contribution if the parent company is paying for the cost of this proceeding?
Yeah, at this point, we're tracking costs, but NIPSCO GenCo doesn't have a lot of costs, of O&M costs.
Who is paying your legal bills for this case, for GenCo?
I believe those are all being tracked through a special accounting code, and ultimately will be allocated appropriately between NIPSCO when it's NIPSCO time and GenCo when it's GenCo time.
By hour, or are you splitting them? Are you doing an hourly tracking, or how?
It typically will track our hours.
Is that what you're committing to today, that you will be tracking hours for the expenses of this case, or how is that working?
Not making any commitments at this point. I'm just telling you currently what we're doing is we have a billing code with respect to GenCo, and we bill our time accordingly.
But cash does need to go out the door to the external law firm you're using right now, right?
That would all be at the accounting level.
So you're just going on credit, or?
Again, NIPSCO Holdings 2, which is the parent of GenCo, it would be at that level as those bills are paid.
Okay, so they're paying the bills right now.
I believe that's right.
Looking please at what's been marked as CACCX 4. So for example, right now you have both your in-house counsel, Mr. Likens and Ms. Murray, who are both employed by NiSource, who are serving as counsel for record for both NIPSCO and GenCo in this proceeding. Is that right?
That's correct.
And sorry, going back, your response in terms of you'll be tracking the number of hours, is that right? That's how you'll be tracking your legal expenses?
Yeah, we have a billing code with respect to any matter that's set up, and ultimately time is tracked through that code.
Okay, so it's not just here's the grand total, we're going to split it in half or have some type of other allocator?
I don't believe so.
Okay. And that's what, as leadership for both companies, can you say that that's what you will do?
We will track it according to our accounting practices and allocate it appropriately.
So for example, there was a joint motion filed yesterday, which was a 10-page document with legal research and had an attachment to it. Who paid for that?
I have not looked at the billing code for that. I don't know.
Okay. We don't know. Okay. When you are paying for the use of, because we have this data request, but the counsel, your in-house counsel for GenCo, what market price are we paying? Are we paying, what you would get if you build it out? Are you getting a discount for your legal services? What's the benchmark for what GenCo is paying for in terms of legal expenses? How is that being compared to market rates?
So legal expenses are negotiated through NiSource It's a shared service that we use throughout the company. Those rates are negotiated through a process with NISOurce's head counsel.
But given the interrelationship here between NIPSCO and GenCo, you're getting access to well-trained attorneys and legal assistants and all of this, development and training that ratepayers have paid for. How much is NIPSCO getting compensated for that? What is the price that you're benchmarking that to?
Again, the rates are negotiated at the NISOurce level. The time is tracked based upon the billing codes, and then it is ultimately assigned to the appropriate entity.
So you don't know?
I'm not involved in the negotiations at the NISOurce level with respect to the rates for attorneys, no.
And so you don't know if it's benchmarked against a market price or anything like that?
Yeah, I'm not part of that process.
Okay, thank you. Moving on to CAC CX4. Oh, I'm sorry, 5, pardon me, which is GenCo's response to IG 2-002. Do you see that?
I'm sorry, did you say 002? Yes, I do.
Yes, yes. So this, now granted, I understand that Ms. Whitehead is no longer the testifying witness in this case, but initially, she's not an officer employee of NIPSCO GenCo, but she was offering on behalf of NIPSCO GenCo. Can you help me understand that?
I'm not sure I understand the question.
So we asked, so if Mrs. Whitehead is not an officer or employee of GenCo, but she was filing testimony and doing work on behalf of GenCo, who's paying for that?
Yeah, again, she would have tracked her time according to the billing code, and she would have assigned it appropriately.
So when we were talking before that it was yourself, Ms. Shikani, and Ms. Birmingham, those are the 3 part-time, full-time people at GenCo, right? But then we have all these other layers of where GenCo's grabbing NIPSCO talent, right?
We have a shared services model at NISOurce, and there's time allocated based upon work done in the company in multiple different areas.
Do you know how many employees of NIPSCO have been involved in this GenCo proceeding?
I'd have to do an estimate.
Yeah, estimate is fine, please.
And you said employees of NIPSCO
Yes,
in the GenCo proceeding.
yes, part of GenCo, anything GenCo, but yes.
It's an estimate, but I would say 6.
Okay, thank you. And employees of NISOurce?
In the GenCo proceeding?
GenCo generally.
GenCo generally.
Matters.
It varies from time to time, but there's a group of about 10 that work on from NISOurce that includes some NIPSCO, but predominantly NISOurce employees.
Thank you. At this time, Your Honor, I'll go ahead and move for admission just to keep track of everything of CAC CX 3, 4, and 5, please.
Any objections?
No objections, Your Honor.
Okay, Mr. Gilbert,
No objection, Your Honor.
Mr. Hicks,
No objection, Your Honor.
Mr. Friedman,
Objection.
Mr. Miller,
No objection.
Ms. Schultz,
No objection.
Mr. Rampala,
No objection.
and Mr. Cashin.
No objection, Your Honor.
Intervenor CAC CX 3, 4, and 5 are admitted into the record of this cause.
Thank you, Your Honor. pivoting here, do you know how many statutory provisions GenCo is seeking declination of jurisdiction from?
It's attached to my testimony, but I couldn't give you a specific count, no.
So subject to check, it started at over 51, and now we're at over 46. It changed slightly with the settlement agreement?
Certainly some modifications with the settlement agreement.
Okay, but that sounds about right.
It's a number. I don't have the specific number.
Okay. Turning to your settlement reply testimony, please. Page 22.
Yes.
You're there, great. Lines 14 through 15 states, the commission has previously declined jurisdiction with respect to the CPCN statute, so this is not a novel concept. Do you see that?
I do.
You're referring to another cause involving declination of jurisdiction, right?
Generally the concept, yes.
Okay. And then line 15, you cite to cause number 45729 to show that the commission previously declined jurisdiction with respect to the CPCN statute, right?
In the footnote, yes.
Do you know, did they have any other statutes at issue, or was it just Chapter 8.1, 8.5?
I don't know specifically.
I have a copy if you'd like. But it wasn't as many as 51 or 46, right?
My understanding, generally, it's almost complete declination. I think we tried to be more surgical. The reason there are more is because we're trying to only decline those pieces that we think aren't relevant to the structure.
Your Honor, can I have just a moment, please?
Yes, we'll go off the record. We'll go back on the record.
Thank you, Your Honor. Mr. Paresi, you've been handed the order in cause number 45729. And going to page 2 under number 3 where it says requested relief, the company just asked to decline jurisdiction under Chapter 8-1-8.5, right?
I see that reference.
Okay, thank you. You can set that aside, thank you. So there's been some changes. How is NIPSCO defining a mega load customer?
I think initially we said essentially two parts, over 50 megawatts, and not having a rate code available to that customer otherwise. And we have modified that, I believe, to 100 megawatts.
And if you could please look at what's been marked as CAC CX6,
Yes.
which is NIPSCO's response to Industrial's request 3-004. Do you see that?
I do.
The industrial group asked, in NIPSCO's view, are there potential circumstances under which a combination of multiple new customers that may not individually be considered a mega load customer be eligible for treatment as a mega load customer? If so, please explain. And then the response says NIPSCO does not currently expect any such circumstances. Do you see that?
I do.
Are you able to commit that you won't be doing aggregation to reach the definition of mega load customer?
Yeah, that is not the intent of this process.
But can you commit to that today?
I'm not making commitments on the stand, but I can tell you that is not the intent of either the GenCo structure or ultimately those customers that would be served under this approach.
So we don't have any certainty even to the definition of mega load customer right now, right?
No, I think we do. I think we said it's 100 megawatts, and they don't have another rate structure under which they could ultimately operate.
But this says, but you're not committing to the fact that it could be like that it could be a combination of multiple new customers. You won't say today that you won't allow that?
It's a theoretical. I can't say that I can foresee every possible combination of large load customer. The intent is to ultimately serve those large load data center customers.
So if there was a customer who had multiple sites that was 20, 50, 30, and they said, we want to be a mega load customer under one.
I don't foresee that being the approach we would take.
Can you say, as leadership of GenCo and NIPSCO, that you will not, that the definition is the definition? We're not allowing aggregation. It's one customer that is over 100 megawatts.
Yeah, I would say the definition is the definition.
So we will not allow aggregation.
I don't foresee an instance where that would be appropriate.
So we have had a lot of very squishy language in this case. Does not expect, does not foresee, does not intend, but your leadership of both companies, can you commit today that we're not allowing aggregation of a mega load to reach the threshold of a mega load customer?
The intent is not to have aggregation of multiple different loads, and that is not part of the definition.
So you cannot commit, correct?
I can commit to the definition.
You cannot commit to the aggregation question that I'm asking today.
I'm saying that the definition does not include aggregation.
But it could change, is what your testimony is.
That's not what I'm saying.
Okay.
I'm saying it's 100 megawatts, and it doesn't, and the customer doesn't otherwise qualify for another rate code.
Your Honor, can I get a yes or no answer on whether or not aggregation of individual customers will be allowed to meet the mega load customer threshold?
Your Honor, Mr. Paresi is committed that NIPSCO will abide by the definition of megaload per the term in the settlement agreement. There are portions of any portion of a settlement agreement that could be open to interpretation. What he is saying is he does not reasonably expect that we would allow aggregation, but he cannot foresee every single scenario. I believe what Ms. Washburn wants is a commitment that is in addition to what is in the settlement agreement and is attempting to modify the settlement agreement on cross-examination. And Mr. Paresi is saying he's not going to make additional commitments not in the settlement agreement, but if she asks him if he will abide by the terms of the settlement agreement, I am confident she will get a confirmation.
Your Honor, I'm asking for clarification of the terms that they put this whole thing forward. Is it aggregated? Are you going to allow customers to aggregate up to that threshold or not? And if they say maybe, then that's the answer and we can move on. But right now, I'm not getting a response to my question. And there's no changing the settlement. We're just asking what they mean. They are signatories. They wrote the settlement. They wrote the case. What's going on here?
Your Honor, I would just clarify, this was a negotiated settlement. Shouldn't assign that we, if she's referring to NIPSCO and or GenCo, wrote the entire settlement agreement. It was subject to negotiation amongst several parties.
So, Mr. Paresi, if you could respond with a yes, no, maybe, I don't know. Just let's try to, get that answer as direct and concise as we can without sacrificing, the truth of your testimony, okay? Would you like Ms. Washburn to repeat the question?
Please.
Will GenCo and NIPSCO allow in the settlement for the definition of megaload customer the possibility of customers under 100 megawatts pooling together to be aggregated to meet the definition of a megaload customer?
No.
Thank you. How will NIPSCO evaluate the asserted power needs of a possible new megaload customer?
The power needs ultimately are brought to us by the megaload customer. They provide us what they believe their load ramp will be, and that's ultimately what we negotiate based upon.
Could you please turn to what's been marked as CAC CX7? So this question asks, how will NIPSCO determine the load requirements of its megaload customers that dictate the amount of energy and capacity GenCo must procure? NIPSCO responds, NIPSCO reasonably expects to determine the load requirements for potential megaload customers based on the contractually agreed to load requirements in each special contract. Here we have reasonably expects. Can you please tell us, point blank, how will you determine the load requirements?
It's based upon ultimately what the customer's load need is, and that's negotiated as part of the contract.
So can we say instead, NIPSCO will determine the load requirements for potential megaload customers based on the contractually agreed to load requirements in each special contract?
The load requirements will be part of the special contract.
And that is how you will determine the load requirement. So again, here you say NIPSCO reasonably expects to determine. Can we just say NIPSCO will determine?
I can say the load requirements will be part of the special contract.
Can you answer yes, no, or maybe, please?
I ask the question again, please.
Where it says the response, it says NIPSCO reasonably expects to determine the load requirements for potential megaload customers based on the contractually agreed to load requirements in each special contract. Can you say instead of reasonably expects, NIPSCO will determine, and then the rest of the sentence?
So it would read, NIPSCO will determine the load requirements for potential megaload customers based on the contractually agreed to load requirements in each special contract?
Yes, sir.
I think that's accurate.
Great. So that is accurate.
That is accurate.
Thank you. I want to take a step back, please. We talked a bit about how NIPSCO's evaluation of whether or not the data center load is coming has changed. The criteria has changed a bit between a signed NDA versus what I read as the attachment to the Clean Grid Alliance testimony. In terms of understanding the load that we're talking about here, do you know what NIPSCO's peak is as part of the IRP?
Currently,
Yes, as part of the IRP projected.
our current load is around 2,400 megawatts.
Okay. And so in the IRP, subject to check, it was 2,300 megawatts. So it might be the number you stated as current. And then NIPSCO projected a range of additional load from the data centers of 2,600 to 8,600 megawatts. Is that right?
That's correct.
So double to, quadruple the number, right, of what your current peak is.
That's what was included in the IRP.
Okay. So you would agree we're talking big dollars, lots of projects. This is a game changer. Is that right?
Potentially.
Okay. If I could have you please look at the settlement agreement. And I know, Your Honor, I'm not sure that we have the updated settlement agreement yet.
The settlement agreement itself has not changed. The Exhibit A, which lists the specific Indiana code chapter or section sites, does have a few typographical errors where it references section A something or B something. Be happy to clarify those in the court reporter's copy. I also do have a corrected PDF copy in my inbox that can be submitted. Happy to proceed however Your Honor wishes to.
Okay.
Okay.
I can navigate around it.
Okay.
Thank you. I just want to make sure I was looking at the right document and had the right figures and whatnot, but I think I can navigate around it. If I could have you look, please, at its paragraph A3, Romanet I, which is on page 13. And it's the first line that we're going to look at there.
Okay.
Thank you. So that reads, prior to the construction, purchase, or lease of a generation asset or group of generation assets, GenCo will make a filing seeking either approval of the generation resources as reasonable and necessary to serve expected load growth, or declination of the commission's jurisdiction provided by Indiana Code section chapter, right, 8-1-8.5 is in the public interest. Do you see that?
I do.
Okay. And that section symbol should probably be chapter, right?
That probably should be changed.
Okay. Is this language in the settlement, are you setting up a new standard that the commission would have to abide by this provision?
I think what we're requesting is declination of certain sections. We originally requested declination of the entire CPCN, and what we're doing is requesting a modification, which I think is permitted under the code.
So it's different than what is under 8-1-8.5, right?
I think in parts, yes.
So with this settlement, we're making new policy, right?
Not new policy. I think this is permitted under the code. The commission has the ability to decline in whole or in part different sections of the statute to enable effectively something like this, to enable us to create a means of both meeting large load customer needs while at the same time protecting our base customers from those costs.
The term reasonable and necessary to serve expected load growth, that's a new standard, right? There's nothing in code that has that phrase, right? Indiana code?
I'm not sure that it is.
You talked a bit with Mr. Freeman about House Bill 1007. So you testified a bit about that bill, right?
Correct.
And you're aware that was enacted on May 6th,
I am.
and that was before this settlement was filed, right?
I believe that's correct.
Okay. Yeah, we found out about the settlement a couple days before, and then it was finalized and filed later. Okay. And so you've reviewed the new IURC processes for an expedited generation resource plan described in the bill, right?
I have not reviewed the processes yet.
In your reply testimony, settlement reply testimony, page 27, lines 1 through 15.
Could you give me the page again, please?
Sure. Page 27, lines 1 through 15.
Yes.
Okay. So that's what I'm talking about. Does that ring a bell?
If the question is, am I familiar with House Bill 1007? Yes, that I think appropriately summarizes
Okay.
portions.
If I may approach, Your Honor, I do have a copy of the House bill that might be easier for us to walk through.
Okay, we'll go off the record.
No, it's okay. Yeah, thank you. Appreciate it. Thank you.
We'll go back on the record.
And so this was the House Enrolled Act that you referenced in your testimony, right?
That's correct.
Turning to page 11, please. So I've, for clarity of the record, I have provided a courtesy copy to the witness of House Enrolled Act number 1007. And page 11, a little bit, third of the way down, there's section 23. Do you see that?
I do.
And then under section 23B, 1, this talks about the, this starts to go into the, well, I guess section 23 just generally, where if you read it, it's for approval of a project to serve a large load customer. So this is the large load customer project pathway, right?
This is a pathway under 1007, that's correct.
Okay. And it talks about how a utilities petition must include some financial assurances there at section 23B 1A. Do you see that?
I see that.
Okay. And the utilities petition of a large load customer project, it says it must include other factors like a description of how the project will support the provision of electric utility service with reliability, affordability, resiliency, stability, and environmental sustainability. Is that right?
I see that.
And those are the 5 pillars, right?
That's correct.
But the settlement does not ask the commission to consider any of that, right?
1007 isn't a requirement. These code sections are available, but the code also specifically says that they aren't required to be used. We can use other available provisions in the statutes.
But the settlement does not provide that you would do those things, right?
Does not.
Okay. Thank you. You can set that aside, please. Moving to the next cross exhibit, please. It's CAC CX8. And that is GenCo's response to CAC 12-01. Do you see that?
I do.
So this was some data requests that we served trying to understand your settlement reply testimony. We reference a section of your settlement reply testimony and ask, there was an objection here that says, GenCo objects to this request on the grounds and to the extent this request is vague and ambiguous, in that the inclusion of the words "that megaload" set forth in the request materially changes the testimony. So if you look at Part A, do you see where we inserted in brackets "that megaload"?
I do.
So what do you mean then if it's not megaload? Feel free to pull up your testimony. It's page 10 of your settlement reply if you need a bigger context.
And I'm sorry, what's the question?
So if you look at the objection and then the response to A to C of the data request of CAC CX8, it says that your testimony does not include that megaload. And you objected to the use of the words "that megaload" that were inserted there. And then you say, he has no opinion on whether there are resources megaload customers would not want to use. So we're just trying to understand your testimony here. What are you meaning here if it's not megaload customers?
I'm sorry, I'm just not connected the dots. I think what my response is saying is that I don't have an opinion on what kind of resources a megaload customer ultimately would use.
Okay, so, and again, looking at the top of the request here, it says, we're quoting lines 13 through 15, and it says, or require reliance on resources customers do not want to use. What customers are you talking about there? If you don't know, you can say that and we can move on, but
I'm not sure. I'm not sure I'm connecting the dots on the question.
Okay, thanks. We talked a little bit about GenCo's targeted return on equity, which you reference on page 39 of your settlement reply testimony, lines 1 through 3. You state, GenCo is likely to request the opportunity to earn a return above NIPSCO's regulated return on equity, as the return profile of an investment should be commensurate with the risk presented. So what methodologies would GenCo use to determine a reasonable risk-adjusted return on invested equity capital?
That will be dependent upon the negotiation between us and a counterparty, and ultimately what risks each of the counterparties takes in that negotiation and special contract.
Can you please describe the risks that you're thinking of when you say that?
Well, in a traditional structure, ultimately, we would file for a CPCN for generation that we would construct, and with approval of that, our customers would take on the responsibility of that construction. Under this construction, we don't have that backstop. All of those risks with respect to the build, the utilization, the payment are all between us and the counterparty. So it's all of those risks.
But there are risks that retail ratepayers could face, right, if this goes south?
I'm not sure what risks those would be.
What about a hit to the credit rating that would flow to NIPSCO?
If this was ultimately a NIPSCO direct relationship and there were a hit to the credit rating, the customer would take that hit as well as have the responsibility for those assets.
So you agree that that could happen? The GenCo proposal does not insulate ratepayers from that, right?
And I don't think we're trying to say we're going to insulate ratepayers from every possible risk. We're trying to ring fence the assets to insulate our customers from the major expenses and costs.
And interveners put forward a laundry list of ways that could better insulate customers, right?
I think other proposals have been included in various testimony, yes.
So NIPSCO retail customers are taking on the risk, but will they see the revenue pass back to them? Any increased revenue? What benefits are they seeing?
As I said before, first, the customers with this structure won't take on the responsibility with respect to any of the assets that are constructed for the use or for the benefit of those large load customers. We think that's a significant difference between a traditional structure. Beyond that, any customer, a large load, mega load customer that's going to utilize the system for purposes of their service will have to pay a fee back to the system, which ultimately will go to all our customers. So customers will see that benefit without any of the risk associated with the construction or operation of those assets.
We don't have any specifics, right?
Those will be included in the special contract.
But again, you're asking the commission to approve without any specifics.
The commission will have an opportunity when a special contract is introduced to make a determination as to whether or not it thinks the risks are appropriately balanced.
So do you think that that invites litigation in every case going forward? Every special contract, every PPA, we're going to have to litigate and litigate and litigate. Is that efficient use of anyone's time?
I can't opine on what the parties ultimately will do. Once they've been able to see a special contract, they may litigate, they may agree.
But there were certain items put forward to try and insulate this risk. For example, the commission could identify a triggering event to set a baseline for changes in NIPSCO's credit rating so that NIPSCO customers can be compensated for the additional cost of debt caused by GenCo's operations. Are you opposed to that?
Again, I think in a special contract filing, those items can be brought forth.
And you'll allow any party into that proceeding, right?
Any party that has a jurisdiction or has a reason to be at the table, certainly. And again, ultimately, that's not our decision to make. That's the commission's decision to make who has intervening authority.
So when I was asking about the triggering event to set a baseline for changes in NIPSCO's credit rating, no, you won't agree to that now.
Again, this structure insulates customers from...
Your Honor, could we do yes or no? We're running out of time. I'm trying my best, but yes or no, are you agreeing to that?
I'm not making any commitments from the stand.
Okay, so no, correct?
Correct.
We also recommended that there be an opportunity for NIPSCO retail customers to share in earnings above a specified threshold. Will you agree to that?
Again, not making any commitments from the stand.
Kick the can, right?
Again, customers will benefit from the relationship, and that benefit will be encapsulated in the special contract.
What about jurisdiction over, what about the life of the generation units? So if GenCo builds the generation units, NIPSCO contracts for that output, and then, it's a 15-year contract, but the life of the unit is 30 years. Can you commit now that they're going to be charged, the price paid, the lower of the bid or the unrecovered plant balance? Can you commit to that now?
Again, all of that negotiation will happen in the special contract, which will be presented to the commission for the commission to ultimately review.
So if it's a 30-year unit and there are only 15-year contracts, couldn't we be in a spot where NIPSCO is paying twice to GenCo, to its affiliate?
Again, we're not asking the commission either in this proceeding or in a subsequent proceeding to approve recovery of the assets from base customers. That's the entire purpose of this. We're not foreclosing the opportunity. Down the road, if in an IRP there's a need ultimately for generation assets and GenCo has assets, to present those in a subsequent proceeding to the commission. But again, that would be for the commission to make a decision about.
So no, you cannot commit today to allowing that the price paid for GenCo assets and PPAs between NIPSCO and GenCo be the lower of the bid or the unrecovered plant balance.
Yeah, that'll all be in the special contract.
So answer is no, correct?
Not making any commitments today.
So we've talked a bit about cause number 46097, which was a unanimous settlement. Are you aware of that?
46097.
The I&M
I&M
data
case.
center.
I'm aware of that case, yes.
Okay. And they had provisions such as early termination, regarding early termination, exit fees, load reductions, so we can make sure that we're insulating existing retail customers in case the mega load customer reduces load or seeks to terminate the contract early. Will you commit to at least having those in your special contracts?
My understanding in that case, customers are not insulated from the costs associated with the generation assets.
I'm sorry, so would you agree to have early termination language in every special contract for this proposal?
Again, all of that will be included in a special contract.
So the answer is no.
That's correct.
Exit fees.
Your Honor, I'm going to object for a moment. Mr. Paresi has repeatedly said he's not here to make additional commitments beyond what are in the settlement agreement on the stand. For sake of efficiency, I would request that Ms. Washburn make her arguments post-hearing if she would like as to what she would like to see. She does have a right and is welcome to walk through specifics and then ask him if he's going to make the commitment and get a no. But the answer is going to be no to any commitment, as Mr. Paresi has said. So I do believe it's much of an inefficient use of everyone's time here to continue to just ask the question to just get a no. But again, if she would like to do that, it is within her right.
Your Honor, in a different circumstance where in rebuttal and reply testimony, we are having those entities specifically respond to our recommendations. The problem is they didn't specifically respond to every single thing here. So it's very difficult to have a clean record and understand what petitioner is committing to for this new process, kicking everything down the road. You know, it's hard to understand what's going on here. So that's the nature of the questions, is trying to get clarity of the fact that the rebuttal and the reply doesn't address these in great detail.
Your Honor,
I'm trying to move along as quickly as I can. I can go ahead and move on from that question, though.
sure, and Your Honor, I would just note that the settlement agreement itself is what is before the commission for approval. It is, in my opinion, clear as to what it does include, and if something is not included, it thus is not part of the settlement is not a commitment per Mr. Paresi's testimony that NIPSCO or GenCo are willing to make. So if it's outside of the scope of that settlement agreement, it is not going to be a commitment that is made because it is the settlement agreement that is before the commission to approve.
I already said I can move on, so thank
Okay.
you. Turning to CX9, please.
Yes.
So, so again, this was what we were just talking about, right? Asset transfers and whatnot. If there is an asset transfer, NIPSCO must demonstrate that the resource has been selected as part of an open competitive process run by a third party. We asked, but we then specifically were trying to get some clarity there, saying with respect to GenCo assets being sold to NIPSCO, if a GenCo asset wins the bidding process. So this goes to what we were just talking about. Mr. Paresi, again, if you could just confirm that you will not be making that commitment as noted in the response.
That's correct.
And similarly, CAC CX10, please, which is GenCo's response to CAC request 11-06. And here we are talking about similar type of question, but again, if you can just read the response and let me know that whether or not GenCo will commit to this or if you are pushing it off to the next proceeding.
Yeah, we'll not be making a commitment today.
Okay. Just so I keep track of everything, Your Honor, I'll go ahead and move for admission, please, of CAC CX 6 through 10.
Any objections, Mr. Likens?
No objections, Your Honor.
Mr. Gilbert?
No objection, Your Honor.
Mr. Hicks?
No objection, Your Honor.
Mr. Friedman?
Objection.
Mr. Miller?
No objection.
Ms. Schultz?
No objection.
Mr. Rampala?
No objection.
Mr. Cashin?
No objection, Your Honor.
Intervenor CAC CX 6, 7, 8, 9, and 10 are admitted into the record of this cause.
Thank you, Your Honor. I did want to ask, though, on this asset transfer aspect and whether or not there were a fire sale, things of that nature, can you at least agree that other familiar investors like Blackstone would not be welcome to the sale of such assets?
Can you repeat the question?
Well, would Blackstone, can you commit that Blackstone will not be able to purchase the assets created out of this arrangement?
We're not committing to who could or couldn't purchase assets from GenCo at some point in the future.
So Blackstone could buy assets created out of this arrangement, is your testimony?
Assets not paid for by our base customers. I think any asset transfer we would make would have to be approved by the commission.
So the answer is no, you would not commit to Blackstone not being able to participate in that.
That's correct.
Okay. So Blackstone could purchase these assets, correct?
I think they could participate just like anyone else.
And that's related to the initial sale, but what about subsequent sales?
I'm not sure I understand the question.
So for example, if there was a subsequent sale, there's an initial sale of, so if there's a middleman, can Blackstone ultimately end up with the asset?
Any assets that are ultimately developed under this structure are developed for NIPSCO to use to serve large load customers. If we're talking about a theoretical end of life, what could happen to the assets? We could sell them into the market. We could provide an opportunity for them to come back to base customers. We could continue to operate them under GenCo for other large load customers.
Do you not agree
Multiple things
that?
could happen.
Sorry.
No, that's okay.
Do you not agree, though, that Blackstone would be an inappropriate taker of such, inappropriate entity to participate given its minority interest in NIPSCO?
I think with respect to the sale of an asset out of GenCo, any party that ultimately wanted to participate in that, if that eventuality happened, could participate.
Turning to the next cross exhibit, please. CAC CX11. This is NIPSCO's response to industrial request 3-001. This asked, has NIPSCO conducted any analysis regarding whether and to what extent the proposed arrangement with GenCo will impact the level of debt on NIPSCO's books or otherwise have an effect on NIPSCO's capital structure? If so, please provide such analysis. And it said NIPSCO has not conducted any such analysis. Has that changed?
It has not.
Thank you.
So at this time, it is 3:01. We had a planned break at 3 o'clock. Is now a good time to break, Ms. Washburn? All right.
Thank you, Your Honor.
We'll go off the record. We'll come back at 3:15. All right, we are back on the record.
Thank you, Your Honor. During the break, I spoke with Mr. Likens about evaluating some cross exhibits to stipulate into the record, given that we're covering a lot of the same ground about commitments, the commitment type of cross-examination. So given the time and the cross-examination planned by the other parties and 2 other witnesses, Mr. Likens is going to be looking through that stack, or his counsel is. So at this time, if I could reserve the right to come back to cross Mr. Paresi while that occurs. Thank you.
Okay, thank you, Ms. Washburn. Mr. Miller, if you have any cross?
Yes, I do. Just a few subjects to discuss. Appreciate it. Good afternoon, Mr. Paresi.
Good afternoon.
My name's Clay Miller. I'm counsel for intervener Clean Grid Alliance. I'd like to first direct your attention to page 10 of your settlement rebuttal, Exhibit 1SR. And I believe, actually, Ms. Washburn had a question about a similar part, but my question is different, I promise.
At page 10?
Yes, page 10. I'm looking specifically at line 11. Could you read that sentence beginning with rate 531?
Rate 531 requires at least 10 megawatts of firm service and has no theoretical cap on the amount of load to be served under tiers 2 or 3.
Thank you. So am I correct to understand that a mega load customer could qualify under tiers 2 or 3 of rate 531?
No, I don't believe so.
And why do you not believe so?
531 was created for industrial customers, and that's specific in the rate structure, as well as created for a very discrete point in time. Customers that had, it was really created as an ability to ultimately transition away from some coal generation and allow for those customers that had helped kind of in that process ultimately transition, into a different market.
Is such a transition required to take under that rate?
They're required at a minimum to be an industrial customer.
Okay, and is the characterization as an industrial customer one of the amount of load?
No, it's the type of work ultimately that they do, the type of business and industry that they're in.
But in terms of the load caps, or the lack of a load cap, if a mega load customer fit your definition of an industrial customer, they could qualify under 2 or 3 based on their load. They would not be disqualified for the amount of load.
I think they would. We had not contemplated in the creation of any of our rate codes this kind of customer, the size of this kind of customer or the nature of this kind of customer.
Okay. Could you read the next sentence beginning on line 13, please?
Beginning with nevertheless?
Correct.
Nevertheless, the load of a megaload customer, such as a data center customer, would put severe strains on the market resources used to serve these tiers or require reliance on resource customers do not want to use.
A couple of questions about that. What resources do these customers not want to use?
Depending on the counterparty, they all still have sustainability goals, so they still have a desire when it comes to the kind of capacity ultimately they're served, short and long term. It varies by counterparty.
And so sustainability goals is something you've heard from the megaload customers you're talking about that they would like to pursue with their power purchases?
That's correct.
And in the middle of that sentence, you refer to putting a severe strain on the market resources. What are you talking about there, both in, well, first of all, am I correct that you're referring to existing market resources?
That's correct. During our IRP process, we run an RFP to ultimately see what resources are available in the market. Where we are with respect to many of the different negotiations is the resources ultimately would likely need to be constructed.
Okay. And those you're preferring would be constructed by GenCo?
Correct.
But in terms of the strain on market resources, it's a matter of new generation needing to be constructed.
On a timeline consistent with the load ramps that these customers would like to see.
Let's see. Do you know if any of the customers in the, well, do you have any customers currently buying under tiers 2 or 3?
We do have customers on the 531 structure. I believe some are in, I can't tell you exactly which tiers they're in.
Okay. Do you know whether any of those customers are experiencing difficulty, for example, acquiring resources through MISO?
I don't know.
And is the difficulty that you're referring, or the severe strain that you're referring to, one of getting those resources online?
That's certainly part of it.
I'm sorry, the additional resources necessary?
That's certainly part of it, yes.
But those, at least in terms of building new resources and getting those connected through MISO, well, let me back up. Would any new resources that get built to serve this load have to interconnect through MISO?
For us, they would.
And under MISO's rules, is there any preference given to a utility affiliate over an IPP?
There's currently a process at FERC referred to as the ARIS process that would expedite the approach with respect to moving generation resources through the process at MISO to get them on the system. I don't know that it necessarily gives a preference.
Expedite for an IPP as well as for a GenCo?
I think based upon a state need.
So no additional preference for GenCo?
Not that I'm aware of.
I'd like to turn next to page 17 of the same rebuttal testimony. Pardon me. And actually, if I may approach, Your Honor, I want to distribute a courtesy copy of a data request response.
Yes, we'll go off the record.
Yeah. Thank you.
We'll go back on the record.
Thank you, Your Honor. I've distributed a copy of a page which was attached to Clean Grid Alliance Exhibit 1, part of attachment 1B, page 7. It's near the end of Ms. Piontek's originally filed direct testimony. And this is a response to Clean Grid Alliance Request 1003. The first question I guess I have for you, Mr. Paresi, is I note that in the request itself, we are referring to a response from NIPSCO to a CAC data request that indicates that NIPSCO GenCo expects to benchmark against competitive RFP results and/or may utilize competitive procurement to provide capacity and energy requirements to serve NIPSCO's megaload customers. Do you see where I've read that?
I do.
And do you have take any issue with that statement being a position of NIPSCO or NIPSCO GenCo?
I don't.
And then jumping down to the response itself, beginning with the paragraph, however, do you see 6 separate enumerated factors that NIPSCO GenCo lists that it would utilize for competitive procurement?
I do see those.
Okay. And could you just read the fourth one? We don't have to read all of them into the record, but I'd be interested in just affirming the fourth bullet point there.
The availability of resources through existing relationships and/or brokers.
And again, that is a factor that would be taken into account if you were to utilize competitive procurement for serving NIPSCO's megaload customers, correct?
Yeah, if we were to use competitive procurement, that would be a factor we would look at.
And again, up at the top, what we read is that you may utilize competitive procurement.
That's right, we may.
Okay. I now want to turn to page 10 of your rebuttal testimony. No, I apologize. We already did page 17. And specifically the sentence beginning on line 11 that begins without GenCo.
I see that.
Could you read that sentence, please?
Without GenCo, NIPSCO would not be obtaining the power to serve megaload customers through PPAs with IPPs.
And is that, are you differentiating between, or rather are you carving out PPAs with IPPs from your commitment to potentially utilizing competitive procurements? Or is there some other explanation?
I don't think there's a distinction there.
Well, obtaining power to serve megaload customers through PPAs and IPPs would be a form of utilizing competitive procurement, would it not?
Utilizing a PPA as a form of competitive procurement?
Yes.
Yes, that's a possibility.
And a PPA specifically with an independent power producer or an IPP?
Is a possibility.
Okay. So the next sentence there, beginning on line 13, arguably that would be too risky because of the risk of relying on a party not under common control. Could you elaborate why that's too risky?
Ultimately, NIPSCO is responsible for meeting that load of any customer that we have. So if we have to be certain that ultimately any generation that we contract for, whether it's through a BTA, a self-build, a PPA process, is going to show up. It has to be there. So there's risk associated with relying on a third party when it comes to ultimately ensuring that we're going to meet that need.
And so isn't the way to eliminate that risk to build it yourself as opposed to set up an unregulated affiliate?
NIPSCO GenCo would build it themselves.
And NIPSCO GenCo would be an unregulated affiliate.
Not unregulated, differently regulated.
Okay, thank you for the clarification. Okay. And I think you also referred in one of your responses to Ms. Washburn that there is no risk to customers from assets built to serve megaloads by GenCo. Is that, do you recall that statement?
I think I said that the purpose of setting up GenCo is to ensure that we ring fence the assets that will be utilized to serve that large load customer so that our base customers don't have the responsibility, the financial responsibility for that build.
Okay, so that's a way to mitigate risk for customers.
Correct.
Is not acquiring power from an IPP mitigating, doesn't that have the same mitigation function? Because there's no way that the customers would be on the hook for the IPP's investments.
Not if ultimately that purchase is made by NIPSCO. If the purchase is made by NIPSCO, we'd go through a process of approval. Once the commission approved it, all our customers would be responsible for that.
For the IPP's investment?
For whatever that generation asset is that ultimately we were going to utilize to serve the customer.
And that's different from the way it would be under the GenCo arrangement?
Absolutely.
There's no, okay. And then, you said that these details will be provided in a special contract. Are these the risk mitigation details that you're talking about?
Yeah, the entire relationship between NIPSCO and the large load customer will be encapsulated in that special contract, and risk mitigation will be part of that. And ultimately, which party holds the risk will be in that.
Okay. And again, that special contract could be with GenCo, it could be with an IPP.
No, the special contract will be between NIPSCO and the large load customer.
But you could have a special contract between NIPSCO and an IPP. I'm sorry, the IPP could have a special contract with the megaload customer.
I don't think so.
Okay. Well, then I apologize, I'm confused.
And I may be confused, but a special contract is ultimately utilized in this scenario for us to capture the roles and the responsibilities between NIPSCO and the large load customer.
So it's got a contract where it commits to provide service to its captive customer, a megaload customer in this case, and it has separately arranged to acquire the power that backs up that special contract, correct?
Yeah, that'll be through a PPA between NIPSCO and GenCo.
That backup.
The capacity and power necessary to serve that customer, that's correct.
And why couldn't it also be with a PPA between NIPSCO and an IPP?
Because again, ultimately NIPSCO is responsible for serving that customer. We have to ensure the generation is going to be there.
And so you never buy power from IPPs?
No, we do.
Okay. Okay, well, those were the two areas of questions that I had for this witness, Your Honor.
Okay, thank you. Ms. Schultz?
No questions, Your Honor.
Ms. Vlasic?
No questions, Your Honor.
Mr. Cashin or Mr. Haas?
Yes, Your Honor, we do have a few questions.
You may proceed.
Thank you. As an initial matter, I wanted to ask, just out of curiosity perhaps, you've interspersed the term large load customer as well as megaload. Is there any reason for that?
There isn't. Megaload, I think, is the term we're using, and I should probably be better at just saying megaload.
Okay, thank you, sir. So I should have introduced myself. My name's Adam with the OUCC. We've met a couple times.
We have.
It's Good to see you again.
You too.
I'd like to direct you to page 9, lines 5 through 7 of your settlement reply testimony. Let me know when you're there.
And I'm sorry, the lines again?
5 through 7.
Yes, I'm there.
You testified that NIPSCO has a right to enter into a special contract with any customer, and the settlement does not impact that, correct?
That's correct.
In your opinion, if a current rate 531 customer were to stop taking rate 531 service and enter into a special contract, they'd be able to do so, is that right?
I don't think so. I think under the settlement, they'd have to meet 2 criteria. One is they would have to be at 100 megawatts or more. The second criteria is they would not have an available rate structure. A 531 customer would have an available rate structure.
Perhaps I was unclear. I'm asking whether or not a current 531 customer is able to take service under a special contract, perhaps not as a megaload customer, but as a special contract customer in general, not a special contract customer under the settlement. Does that make sense?
Oh, I understand. I believe that's the case.
Okay. And based on the definition of megaload customer in section A2 Romanet 2 of the settlement agreement, which we've been discussing, I think, if a rate 531 customer were to do so, were to move to a special contract, would they meet the definition of megaload customer?
I still don't think they would, because under the definition, it's a 2-part test. They have to both be at 100 megawatts and not have a structure available to them. They'd have 531 available to them. So I don't think they could then meet the definition of megaload customer.
In other words, they don't qualify for, they would still qualify for rate 531 service.
That's correct.
Okay. In the case where a 531 customer stops taking 531 service and enters into a special contract with NIPSCO, could NIPSCO serve that customer with GenCo assets?
I don't believe so.
Thank you. Do you have the stipulation and settlement agreement before you?
I do.
Okay. I'll direct your attention to page 14 of the settlement agreement. In the top of the page, in the sentence that reads, GenCo will retain eminent domain authority only for purposes of the resources that will be developed by GenCo and contracted for by NIPSCO for use to serve NIPSCO's retail customer load. Do you see that?
I do.
And it's GenCo's contention, is it not, that eminent domain authority is appropriate because it is providing generation for NIPSCO to serve NIPSCO's load. Is that right?
That's correct.
Does GenCo think it is appropriate for any independent power producer to have eminent domain authority if it is contracting to provide generation to a regulated utility?
I do not. I think this is a unique approach. If NIPSCO retained the authority and did this, we would have the eminent domain authority. It's not something that we use lightly. This is an extension of that relationship, that all of the generation that ultimately is created by GenCo will be used for NIPSCO to serve these megaload customers. And there may be times where ultimately we need that authority to construct the assets.
You seem to be making some kind of distinction, but I'm curious why it would be appropriate for only GenCo to have this authority, but not other independent power producers. Can you flesh that distinction out a bit, please?
Yeah, again, the GenCo is being created ultimately for 3 reasons. One is to create a structure that ultimately insulates our customers, our base customers, from what could be large load construction and costs associated with that. The second is speed and pace. For us to be able to meet the customer's needs, ultimately we need to be able to move quickly. And the third is ultimately to protect NIPSCO. Creation of GenCo is different than an IPP. We are not declining jurisdiction or requesting the declination of jurisdiction over everything. We've been fairly specific with respect to the sections that would apply. That's different than I think what typically happens when an IPP comes and asks for declination to construct and then ultimately transfer that asset to a third party.
Isn't it true that you, GenCo and NIPSCO, have, it seems like there's been kind of a conflation between whether or not you are akin to independent power producers or distinct from them. The answers to a number of questions seem to go back and forth. Do you agree with that?
I think we use the reference to the IPP and declination in that scenario because it's something that's familiar. When it comes to GenCo specifically, it sits more in the regulated than the unregulated space. The intent is not to move into the unregulated space and to use GenCo the way an IPP may move from place to place and space to space to create generation. This is a very specific entity that we've created to meet a very specific purpose.
As a regulated public utility, is it correct that NIPSCO has used condemnation proceedings and otherwise been involved in condemnation proceedings in the past?
We have, but we use them very sparingly.
But you've been involved in them, the company has?
Yes.
You're familiar with the Duke v. Noblesville case from 2024, is that right?
I believe I am.
Okay, you did discuss it in your settlement reply testimony.
That's right.
And I think in your testimony, you note that GenCo would have the ability to come before the commission to review regulations under the Noblesville case. Is that right?
That's correct.
Okay. But GenCo would be able to condemn property under its eminent domain authority without coming to the commission first.
I think with respect to the settlement, what we've said is that as part of the filing, we will also provide evidence of the steps that we've taken to ultimately avoid the use of eminent domain authority.
I'm glad you mentioned that. Is that not just a legal requirement as far as using the eminent domain authority?
It is.
Okay, thank you. Direct your attention to page 18 of your settlement reply testimony, please.
Yes.
Specifically lines 9 through 10. Do you see that?
I do.
And you note that, well, I actually have a partial quote. You say IPPs are typically not subject to the commission's investigation and complaint jurisdiction, and this means a condemnation action could be filed at the commission. I want you to focus on those last couple lines there. A condemnation action complaint could be filed at the commission. Do you see that in your testimony?
I do.
In your experience, has such a condemnation proceeding been appealed or otherwise reviewed by this commission?
Not that I'm aware of.
Thank you. Isn't the point of a condemnation proceeding in a local circuit court to make sure that that authority, the eminent domain authority, is being exercised properly?
It is, and we would approach it that way. The purpose of ultimately continuing to have that authority is that in a situation where the local authority wasn't using their approach to put reasonable things in front of us, it would be in a situation where they just had no desire to have that local presence with respect to whatever that might be, whether it's that generation resource. And so at times you just have to bring that to a different venue.
Your Honor, may I approach the witness?
Yes, we'll go off the record.
Thank you.
So just before we go back on, Mr. Cashin, we can take administrative notice of this order because it's our own order rather than entering it as a cross exhibit if that's convenient.
That's perfectly fine, Your Honor. Thank you very much.
So when we go on the record, I'll make note of that. All right, we'll go back on the record. So we take administrative notice of the January 31st, 2024 order by the Commission in cause number 45943.
Thank you, Your Honor. Mr. Paresi, the court reporter has placed before you the Commission's order in cause number 45943, which is a complaint brought under Indiana Code Section 81254, among a number of other statutes, and it was brought to the Commission regarding Duke Energy Indiana's exercise of its eminent domain authority. You familiar with this order?
Generally.
I want to direct your attention to page 4 of the Commission's order here, and specifically the following text. For the reasons explained below, we have no subject matter jurisdiction under any statute to accomplish what complainants seek here, to take action that directly conflicts with condemnation proceedings that are currently pending in state court. Do you see that?
I do.
And now I want to direct your attention to the same order on page 5, specifically the following sentence. It is reasonable to conclude from the plain text of applicable statutes that the legislature did not intend for parties to be able to interfere with a utility's well-established right to pursue condemnation proceedings by filing a complaint of any kind with the Commission. Do you see that text?
I'm not finding it quickly here.
It is in the third paragraph.
I do see it now, yes.
Yeah, middle of the paragraph.
Yes, I do see it.
Okay, thank you. Based on the conclusion from the Commission here, has the Commission already ruled that it will not interfere with condemnation proceedings?
That is the language.
In your testimony, when you say a condemnation action complaint could be filed at the Commission, is that still correct? Is that still your testimony, sir?
I believe it is. I believe someone still has the right to do it, but I do see what you're saying with respect to this order.
May I ask how? How do you still see that? I'm not following what appears to be a contradiction here.
I think under the code, there's still a right of action. I mean, I think people can still file at the Commission and ultimately ask for that to be reviewed.
Ultimately ask for a condemnation proceeding pending in state court to be reviewed by this Commission. Is that your testimony?
I think so.
Even though that is directly opposed to what the Commission said just a year and a half ago.
I do see that conflict.
In your testimony on page 18 of your settlement reply testimony, on line 12, you write that the non-settling parties, when they claim that GenCo is not subject to ongoing Commission jurisdiction with respect to siting and land use, they're simply wrong. Per the Commission's order here, it would appear that those non-settling parties are not at least entirely wrong. Would you agree with that?
No, I think we still have an obligation to bring before the Commission the steps that we've taken to ultimately avoid condemnation action.
Despite the fact that no such complaint will be heard by this Commission per their order in cause number 45943.
I think we still have that obligation.
You're discussing your legal obligation to acknowledge that you have taken certain steps before exercising the eminent domain authority. Is that correct?
That is an obligation we have.
One of the factors the Commission considers when evaluating petitions for declination is whether existing regulation by other state or federal bodies make the IORC's jurisdiction unnecessary or wasteful. You familiar with that factor?
I am.
If GenCo were to retain eminent domain authority, how would it be meaningfully regulated by entities other than the commission?
I think we would still have to take the steps appropriate at the local level to make sure that we're doing everything we can to avoid use of eminent domain authority, and then we'll have to demonstrate that we've done that when we come to the commission.
I want to ask you again, are you aware of any other similarly situated entity that has retained this particular authority?
I'm not.
Okay. Are you asking for a novel authority here, would you say?
I think this is a different situation. So I think what we're asking for is to retain the authority that we have currently. If we were to construct the assets as NIPSCO, we would have that authority unquestionably. And we're not asking the commission to decline all jurisdiction over GenCo. We're being very specific with respect to the components that we're asking for declination.
Okay, thank you. I just have one more topic to shore up, and I'll note you did mention this earlier, so I don't think this will take too long. In the settlement agreement in section A3, lowercase h, Romanet 1, it says that GenCo will either seek approval of a generation resource as reasonable and necessary to serve expected load growth, or will seek a declination of commission jurisdiction over that resource. Do you recall that?
That's correct, yes.
Okay. Is it correct that this provision was not included in the company's case in chief in this cause?
That is correct.
Can you explain why this language regarding approval of a generation resource as reasonable and necessary to serve expected load growth was added?
We initially requested declination of the entire CPCN process through the process of negotiating with parties. That issue was brought up by multiple counterparties without getting into settlement negotiations. Ultimately, we decided that it would be appropriate for us to bring forth a more abbreviated approach with respect to approval of specific assets or groups of assets for a large load customer.
I want to return to something that was noted earlier. This standard that appears to have been created, reasonable and necessary to serve expected load growth. Where did that come from?
I believe we created that for purposes of settlement.
Okay. And that's NIPSCO's load growth, is that correct?
It's the load growth associated with the mega load customers.
NIPSCO's mega load customers.
NIPSCO's mega load customers.
And it's GenCo seeking declination or approval pursuant to its affiliates' load growth, is that right?
That's correct.
Okay. Does this approval confer any rights or responsibilities on GenCo or NIPSCO with respect to the generation assets approved in those future proceedings?
There would be no assumptions or predeterminations with respect to any future proceedings that would be associated with this process.
Okay. And it's not your intent that any rights or responsibilities be conferred on either GenCo or NIPSCO as a result of those approval proceedings?
That's correct.
These approval proceedings will not confer any type of pre-approval status as we understand that term today. Is that right?
That's correct.
And neither NIPSCO nor GenCo will seek to recover any costs of GenCo generation assets from NIPSCO ratepayers other than the megaload ratepayers based on the commission approval described in the settlement agreement. Is that correct?
That's correct.
All right, Your Honor, I believe that's all the questions I have. Thank you, Mr. Paresi.
You're welcome.
Okay, thank you. Ms. Washburn?
Thank you, Your Honor. I understand from Mr. Likens that we have reached an agreement to stipulate, in addition to the, I believe it's up to CAC CX20 that have already been pre-marked, there's about 20 other pieces of paper. But we have those stacked. I wonder if it makes sense to wrap other matters up and do that. I defer to you, but I know that there are two other witnesses and redirect. So
Okay.
whatever you'd like to do in terms of order. And Mr. Likens, please jump in if.
Great. It sounds like you don't have any additional questions for Mr. Paresi at this.
That's right. Yeah, with the understanding that we'll stipulate in the stack of documents that still need to be marked and put into the record. Yes.
Okay. And with that, Mr. Likens, do you have redirect for Mr. Paresi?
I do have some redirect, and we'll try to be as brief as possible.
Okay, if you'd like to proceed at this time, you may.
Mr. Paresi, I'm going to go in reverse order, which means what was most recently asked by Mr. Cashin will be fresh on your memory, but also what was asked by anyone else is going to be even further back in your memory. But in attempts of hitting the points that were just hit and staying on subject, I'll do that. In talking with Mr. Cashin, do you recall his questions related to eminent domain authority?
I do.
And you testified that in your opinion, it wouldn't be appropriate for an IPP to have eminent domain authority. Is that correct?
It is.
Are you aware of anything? Are you aware of anything that would preclude an independent power producer from making a request for declination that it included retaining eminent domain authority?
I'm not.
And are you aware of anything that would preclude them from making a request that would be similar or identical to GenCo's request in this proceeding?
I'm not.
With respect to NIPSCO, Mr. Cashin asked if NIPSCO had used eminent domain authority, and I believe you answered yes to that question.
I think that's correct.
Is your awareness of them using eminent domain authority with respect to transmission or with respect to generation assets?
I'm not aware of the use of eminent domain authority for the generation assets, only for transmission assets.
And pursuant to the commitments that NIPSCO and GenCo have made here, would it be NIPSCO or GenCo that would be building transmission assets related to service of megaload customers?
I think I've said in my testimony that it will be the NIPSCO that ultimately is going to be responsible for transmission assets, assuming there's benefit to the system with respect to those assets.
And then do you recall where Mr. Cashin was talking about the commission order that related to eminent domain, and in essence, they're saying they don't have authority there, and then pointing at your testimony and asking some questions?
I do.
Could a party who lost a condemnation proceeding in state court file a complaint with the commission per the terms of the settlement that GenCo was not complying with the settlement agreement?
They could.
And could they otherwise file a complaint with the commission arguing that GenCo is not complying with applicable law based on the fact that GenCo is allowing retention of all investigatory authority by the commission?
They could.
Now, hearkening back to the questions that were asked by the Citizens Action Coalition by Ms. Washburn, have a few brief redirect here. Are you aware of the fact that NIPSCO has affiliate agreements with other NiSource subsidiaries, such as Columbia Gas of Ohio and Columbia Gas of Kentucky?
I am.
And are the services inclusive of legal services by NiSource corporate services provided pursuant to those affiliate agreements?
They are.
And is it your opinion that the allocation of costs, whether it be for legal services, accounting services, or otherwise, would be done consistent with how NiSource Corporate Services currently allocates cost with respect to NIPSCO and GenCo or NiSource Corporate Services and GenCo?
Yeah, that's my understanding.
Could you get your settlement reply testimony and turn to page 27, please? And let me know when you get to page 27.
Settlement reply, page 27. I'm there.
I'm actually going to reverse you to page 25 just so we ensure that we know the context in which we're speaking, which talks about, and I'll read the question, please provide your perspective on whether the commission should mandate a utility to use a specific means to serve a certain class of customers simply because the alternative exists or another Indiana utility is using that approach. Is page 27 a continuation of your answer to that question?
It is.
And in your own words or utilizing your testimony that is here, could you just reiterate GenCo's perspective with respect to whether House Bill 1007 mandates use of its alternatives that are now provided under 1007, or whether GenCo could do what it proposes to do here?
Your Honor, I'd like to object that I didn't, on the basis that I haven't heard any connection to a specific question that this is redirect on. Redirect is very strictly construed, and Mr. Likens hasn't attempted to link this back to anything other than a bill.
Sure, Your Honor. I would tie it directly to Ms. Washburn's questions about whether Mr. Paresi has reviewed the new IURC processes, which I believe she was talking about the 2 new pathways under House Bill 1007. And then specifically, that is referred to on page 27 of his testimony.
Well, again, just because she asked him about the bill doesn't mean that he can ask him to pontificate further about what else is in the bill.
I'm going to overrule the objection. So if you can answer Mr. Paresi, or if not, we can ask Mr. Likens to restate the question.
I think I have the question. I think it's clear under 1007 that as I said in my testimony, the chapter does not preclude an energy utility from petitioning the commission under or in conjunction with other applicable statutes, and then a number of statutes are listed. I think I said in my response that 1007 is an alternative. It's an option available, but I think the statute was very clear that other existing statutes can be used.
Thank you. And now turning to the questions that were asked by Mr. Friedman on behalf of LaPorte County. Do you recall when he asked you questions about different alternatives that may have been considered and whether there was a study or an evaluation that was performed with respect to before GenCo was filed?
I do.
Could you look at question and answer 20 through 21 of your direct testimony?
I'm there.
Is it fair to say that that portion of your testimony does address or compare the GenCo approach to traditional structures of serving customers?
It does.
And then finally, and very briefly, do you recall the questions from Mr. Friedman about the I&M settlement? I believe Ms. Washburn also asked some questions about the I&M settlement.
I do.
Is it your understanding that that was, in fact, a settlement that was approved by the commission?
It is.
What is your understanding with respect to the precedential value of a settlement at the commission?
That it has none, that it's binding to the parties to that case for that settlement and not binding anywhere else.
Thank you. No further redirect.
All right. We're going to go off the record for a moment. We're back on the record. We have Commissioner Freeman has a few questions.
Thank you, Your Honor. Mr. Paresi, just a few questions here. In your opinion, can a settlement agreement impose a standard of review on the commission that is not in the Indiana Code, or would the standard of review in a proceeding be set by the statutes under which you file a proceeding?
Yeah, my understanding is that a settlement agreement cannot create a standard for the commission, that ultimately it would be the statutes.
Thank you. I'll get closer. I'm held to that same standard. Sorry, Linda. Now I've got to put my words out farther away from my eyes so I can read them. That should have been off the record. Is a self-build, own, and operate the only way GenCo could supply energy or capacity to NIPSCO?
No, GenCo could enter into power purchase agreements. They could do BTAs with someone else that ultimately constructs it and ultimately purchases, brings it over ultimately GenCo. So I think there's multiple different ways for GenCo to retain the capacity it needs to meet the needs that we may have at NIPSCO.
And then are there any financial incentives for GenCo to choose to build, own, operate rather than any of the other methods that you just enumerated?
I don't think financial incentives. I think ultimately the thing that will drive the approach for GenCo is for the most part going to be speed. What kind of generation that's ultimately needed to serve the load, and the pace at which it can build it to meet the requirement.
Thank you, Mr. Parisi. That's all I had, Your Honor.
Thank you, Commissioner. All right. Thank you very much, Mr. Parisi. You're excused. Thanks. We'll go off the record.
If it makes sense, and I'll defer to Ms. Rubel, but I think there's one confidential page in my stack, but we could just make it one giant CX, if that's okay. Yes, okay, yep. So you said we have until 20. And Your Honor, when we go back on the record, then if it's okay with you, I would move for admission for CX 12 through 23 as well as 23C.
Jen, is this CX 24? This.
Mr. O'Connell,
Okay,
Laporte, and then Mr. Thomas.
okay. Okay, so I'll acknowledge that on the record. So first I'll go to Ms. Washburn, then I'll say, I understand there are some corrections to scrivener's errors, then we'll talk about the motion. All right. We'll go back on the record. Ms. Washburn?
Thank you, Your Honor. Previously, I spoke with counsel for GenCo and NIPSCO about stipulating certain data request responses into the record. At this time, in lieu of additional cross of Mr. Paresi, at this time, CAC would move into the record what's been marked as CAC CX 12 through 24, as well as CACX 24C.
Was there a CACX 11?
Yes, Your Honor, thank you, and I did not move that one yet into the record, so I would move into the record then 11 as well, please. Thank you.
Okay, thank you. Any objections? I'll pause for a moment if you have an objection. Now's the time to speak up.
No objection, and we express our appreciation for CAC for stipulating and moving things along very much.
All right, thank you, everyone. Hearing no objections, intervenor CAC CX 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, and 24C are admitted into the record of this cause. As our next item, I understand that there are some corrections to scrivener's errors. Mr. Likens or Ms. Aguilar?
Yes, Your Honor, thank you. There were some scrivener's errors where we referred to a subsection B instead of an A in the settlement agreement, and we are going to pre-file those so that the commission has the most up-to-date copy, and in doing so, it'll be served on all parties of record.
Okay, thank you. Next, we have an outstanding joint motion for limitation of cross-examination by parties with similar interests and supporting memorandum that was filed by GenCo and NIPSCO yesterday on June 30th, 2025. So we will have oral arguments or replies on that motion today. If anyone would like to respond to the motion, you may speak now.
Thank you, Your Honor. I can, especially given time, just cut to the chase. We were prepared. Of course, we're not doing friendly cross-examination. I've been practicing before you all for 13 years. We know how this rodeo goes, so we're prepared. We have, legitimate disagreements with Laporte's witness, in particular as it relates to their reliance and suggestion about rate 531, just like in any case, we're not all completely aligned on every single issue, and that's the case here.
Okay.
Incidentally, LaPorte County would have only very limited questions for Mr. Thomas with regard to the one area that we are not aligned on. Mr. Thomas opines that if there are changes made to the settlement agreement to make it acceptable, we want to question on that, particularly 3 or 4 items there, because it's our belief that the settlement agreement is facially defective and cannot be cured. And we're specifically pointing to items from the 4097 agreement that are not included even in his recommendation. So my questioning will be precise, limited, only to those areas on which we disagree.
Any reply, Mr. Likens?
Consistent with our motion, to the extent that cross-examination is consistent with what was just represented by counsel, we would not have an objection to that. What I would be fine with is a denial of the motion by Your Honor. And To the extent we need to orally ask for an objection to specific questioning, we could do so. But to the extent they're going to be consistent with what they just noted, I don't think we'll have any issues.
Okay, thank you, everyone. Having considered that, I will deny the motion at this time as premature, and we can proceed. Mr. Friedman.
Thank you, Your Honor.
We'll go off the record.
If I could, I'd like to call Mr. O'Connell to the stand, please.
We'll go back on the record, and I understand, Mr. Friedman, you'd like to call Mr. O'Connell. Mr. O'Connell, before you sit, could you please raise your right hand? Do you swear or affirm under the penalties of perjury to tell the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. And Mr. Friedman, you may proceed.
Thank you, Your Honor. Mr. O'Connell, I placed at the witness stand your testimony, specifically testimony in opposition to settlement agreement, which is marked as Report 1, and should have also an attachment A to it. Do you see that?
I do.
You recognize that as your testimony?
I do.
If I was to ask you those questions, the same questions, would your answers be the same as they are in the written portion that is presented today?
Yes, they would. Yes, ma'am.
Mr. O'Connell, do you adopt that testimony, specifically Report 1 and the attachment A, as your sworn testimony today?
I do.
Your Honor, the witness is tendered for cross.
Okay, thank you. Does anyone other than Ms. Washburn have cross? Okay, Ms. Washburn, you may proceed.
Thank you, and Mr. Doshi will be handling this for us. Thank you.
Thank you, Your Honor. Mr. O'Connell, good afternoon.
Good afternoon.
My name is Samir Doshi, and I am an attorney for Citizens Action Coalition of Indiana. And I have some questions for you that relate to your direct testimony. If you remember that, I think that was filed around April 1st. Do you have a copy of that with you?
Yes, I do.
Could you turn on your direct testimony to page 12?
I'm there.
And is it fair to say, before I go to the specific lines, is it fair to say that you have opposed and do oppose the proposed GenCo structure in this proceeding?
Yes, I do, strongly.
Thank you. And on page 12, starting at line 10 of your direct testimony, going to line 12, you wrote, moreover, NIPSCO already has viable alternatives under existing regulatory frameworks, such as Rate 531, to address megaload customer needs, without imposing additional risks or costs upon existing ratepayers. Do you see that?
I do.
And additionally, I'd like to highlight another related passage in your direct testimony. Could you turn to page 20?
I'm there.
And from lines 3 to 10 on page 20, I won't read the whole thing, but I'll try to summarize it. You can tell me if I fairly summarized it. You described what you see as a pathway for megaload customers to utilize the existing rate 531 tariff. Is that fair to say?
It is.
Okay. Thank you. And are you familiar with the circumstances of when and why rate 531, formerly called rate 831, was created?
I'm aware of many of the circumstances, perhaps not all, though.
Are you aware that it was created back in NIPSCO's electric rate case captioned cause number 45159?
Yes, I'm aware of that case.
And that case spanned 2018 and 2019? And would you agree that rate 531, then called rate 831, was designed to retain existing large industrial customers in NIPSCO's service territory?
Yes, that's my understanding.
And would you agree that since rate 531, previously rate 831, was created, no new industrial customers have taken service under that rate?
I'm not aware of any new customers.
Okay, thank you. And would you agree that only industrial customers and no commercial customers are taking service under rate 531?
Yes, that's correct, industrial.
Okay, thank you. At this time, Your Honor, if I may, I'd like to approach the witness and distribute a cross exhibit in the room.
We'll go off the record.
Thank you.
We'll go back on the record.
Thank you, Your Honor. Mr. O'Connell, do you have the new document that we circulated?
I do.
Your Honor, we'd like to mark this document, which is titled Rate 531, as CAC CX25. Sorry, it has been marked as CAC CX25. Thank you. Mr. O'Connell, are you familiar with this tariff text of Rate 531?
I am.
And would you agree that Rate 531 breaks up a customer's usage into 3 tiers, Tier 1, Tier 2, and Tier 3?
That's correct.
And would you agree that under Rate 531, Tier 1 usage is considered firm?
That's correct.
And would you agree that a customer is required to take at least 10 megawatts of Tier 1 firm service?
That's correct.
And do you know if a rate 531 customer may choose to take Tier 1 firm service at a level above 10 megawatts?
I don't know that answer.
I'm sorry, your answer is you don't know?
Yeah, as far as electing optionally to use Tier 1, most financial incentives would have them use Tier 2 and 3 due to the much lower cost than Tier 1.
Okay, thank you. Could you turn to the second page of the exhibit, which is captioned at the top, original sheet number 74. It also says sheet number 2 of 13. Do you see that?
I do.
And midway through the page, do you see the heading Tier 1, firm service?
I do.
Do you see immediately under that where it says, the default Tier 1 contract demand election is 30,000 kW with an option to elect above or below that amount down to 10,000 kW?
I do.
So based on that, I know you just read it, but based on that, would you agree that a rate 531 customer could choose to take Tier 1 firm service above 10 megawatts?
Yeah, certainly they could go up to 30,000.
Would you agree that a Tier 1, would you agree that a rate 531 customer could take Tier 1 service above 30,000 kilowatts or 30 megawatts?
Yeah, it looks like they have the option to elect above that amount.
Thank you. Would you agree it's possible that if NIPSCO served megaload customers under rate 531, a data center with, let's say, 2,000 megawatts of load could have the entirety of its load served under Tier 1?
That would be possible.
Okay. Thank you. Are you aware of the minimum contract term under rate 531?
I believe so, as far as the minimum demand amount.
The minimum length and time of a contract under rate 531?
I'm not exactly sure the number of months for that.
Okay, thank you. Could you turn to the 12th page of the document, which is towards the end? It's marked as, at the top, original sheet number 84. It also says sheet number 12 of 13. Are you there?
I am.
Okay, thank you. Do you see under the heading contract where it says, any customer requesting service under this rate schedule shall enter into a written contract for an initial period of not less than five contract years?
Yes, I see that there.
And based on that language, does it sound reasonable to you that 5 years is the minimum contract term under rate 531?
It does for initial.
And in your experience, would it be fair to say that the typical service life of a new electric generating plant is quite a lot longer than 5 years?
It's going to exceed 5 years, yes, hopefully.
Would you agree that the service life of a new electric generating plant is usually several decades?
Yes.
Would you agree that the typical service life of new transmission infrastructure is typically several decades?
Yes.
And that's longer than the minimum contract term of 5 years. Would you agree with that?
It is, yeah.
And if you stay on the same page 12, still under the heading contract, the second sentence in the paragraph under the heading contract says, the customer maintains the ability to cancel the contract if the entire premise is closing.
I see that, yes.
Were you aware that rate 531 allows a customer to cancel its service agreement under the tariff if the customer closes its facility?
I was not aware fully that they could cancel at any time. That seems like an excellent option for them to have and would be certainly problematic for new customers coming on there, and definitely affects the protections of NIPSCO and its other ratepayers at the expense of rate 531.
Okay, thank you. Can you say more about what you meant by it affects the protections of NIPSCO and its other ratepayers?
Certainly. I mean, there's a minimum of 5 years, but if something happens unforeseeable, they can get out of this contract, and any remaining load or plans or anything that NIPSCO's created, built, would then fall back on every other ratepayer.
Okay, thank you. And if you look at the next two sentences, which say, for customers who are aggregating premises, if one premise closes, the customer may modify its Tier 1 contract demand with 12 months' notice, but it may not go below 10,000 kWs. For a customer partially closing a premise, the customer may modify its Tier 1 contract demand with 12 months' notice, but it may not go below 10,000 kWs. Do you see those sentences?
I do.
And would you agree those provisions allow a rate 531 customer to reduce demand under Tier 1 potentially very significantly within a 12-month period?
Yeah, in the case that their current Tier 1 is over 10,000, then yes, they could drop it down to that minimum if there's a material change in their business.
Okay, thank you. At a high level, are you generally aware that when rate 531, formerly 831, was created back in cause number 45159 in 2018 and 2019, are you aware that NIPSCO used a cost of service study to calculate the rate 531 rates?
Yes, it was part of the rate case and using traditional methods, especially for this Tier 1.
Thank you. Do you agree that the current rate 531 rates would not necessarily reflect the cost of service if new megaload customers were added to rate 531?
I think that's a little complex in that the Tier 1 minimum of 10,000 would be a fraction of a 500 megawatt data center. So this is just a percentage or two of what the total demand would be. So I would think that that impact would be fairly minimal. Those customers would likely, in that case, go on to Tier 3, which is energy that would be outside of NIPSCO's native load and would be acquired with independent third parties or on MISO and federally regulated. So the piece of their load on Tier 1 and part of NIPSCO's load, again, would be a small fraction of their actual demand.
Thank you. And I think you said those customers would go on to Tier 3, is that right?
Right, so they would, Typically, with how the pricing is, you would, if you modeled this, you would take the minimum amount under Tier 1, and then you go into Tier 2 or Tier 3, where you get LMP pricing and typically on any given day, a much lower cost than you would under Tier 1.
So when you said those customers, did you mean new megaload customers?
I meant new megaload customers, and I'd presume current customers are not getting the majority of their energy on Tier 1, but that's an assumption.
Would you agree that the rates calculated for rate 531 currently using a cost of service study would no longer exactly reflect the cost of service if new megaload customers joined rate 531?
Yeah, I mean, there would have to be some adjustments, and I mean, typically this would go through a different proceeding to get that hammered out and be updated. But again, with Tier 1, that would be, in some cases, de minimis amount of energy that these entities would be acquiring. And by entities, I mean megaload customers.
Okay, thank you. And would you agree that currently rate 531 customers pay a three-part rate, including a demand charge, energy charge, and transmission charge?
That's correct.
Would you agree there's no fixed charge under rate 531?
Outside of if they elected a certain amount on Tier 1, 10,000, they would have a known cost based on that demand level. But that's variable based on how much demand they're taking under Tier 1.
Okay, thank you. And can you turn to page 9 of the exhibit, which is titled at the top, third revised sheet number 81. It also says sheet number 9 of 13.
Yep, page 9.
Do you see where it says demand charge, Tier 1, $27.45 per kW per month?
Yes.
Does it specify there a minimum demand-based charge?
It does not, but the minimum is 10,000. Yes. Yes, ma'am.
And what happens if a customer under rate 531 actually uses less than 10,000 kW of peak demand?
My understanding would they would be billed for the 10,000, so that would be a minimum charge.
Are you aware of where in the tariff it specifies that?
In the contract terms that we just discussed, was a minimum of 10,000 is what I believe it. It may not go below 10,000. That'll be on page 12 that we just discussed.
Okay, thank you. Would you agree that other than references to the customer not going below 10,000 kilowatts, of contract demand, this rate 531 tariff does not specify a minimum charge.
I don't think it's explicitly written in here, at least what we've looked at.
Okay, thank you. So if hypothetically a customer joined rate 531 and elected 20,000 kilowatts of demand, or 20 megawatts, the customer would not have a minimum contract charge at 20,000 kilowatts. Would you agree with that?
I'm not sure I'm understanding. If they go below 20,000, would they have to still pay at the 20,000 or?
Yes, thank you. I should have been clearer. If the customer elects 20,000 kilowatts of contract demand under rate 531, and then actual usage, actual peak demand in some month is much less. I'll give you a hypothetical, 11,000 kilowatts. The customer would not have a minimum charge based on 20,000 kilowatts.
My understanding is they would be charged for this, and they have some time to adjust that downward in the contract as far as if a plant closed, but again, it looks like they would still have to pay that amount. And I think from my perspective, looking at this and the time I've spent on this, is again, the tier 1 is so much more expensive than the alternatives, tier 2 and 3, that I would be pretty shocked and if someone was electing additional charges beyond the minimum.
Okay. Are you familiar with the recent approved settlement, which has been much discussed today, in cause number 46097 involving I&M?
Yes, I've read through it.
Are you aware that in that settlement, large load customers have a monthly minimum demand charge based on the greater of 80% of contract capacity or average peak demand of the past 11 months?
I was familiar that there was an 80% charge, and there's some protections for both sides if demand were to drop unexpectedly, that the utility is protected and the customer knows what they're getting into.
And would you agree that a provision similar to what I just described in the cause number 46097 settlement is not in rate 531 for NIPSCO?
No, I mean, certainly, if this were to be adopted, there would have to be likely some strengthening of it, and that would all be discussed in a different proceeding. That it is unique to them and certain minimums and everything that was discussed in NIPSCO and GenCo testimony on typically what you have to do for a traditional rate case to get those protections in.
Okay, thank you. Are you familiar with the TDSIC, sometimes called TDSIC, I think, charges that NIPSCO charges its customers?
Yes.
And are you aware that for purposes of recovery of T-DSIC capital expenditures and costs. For rate 531 customers, only the Tier 1 load gets allocated T-DSIC charges.
That would make sense here, given Tier 2 and 3. And again, with Tier 3, you're outside of NIPSCO's system for the most part. NIPSCO is the market participant, but the customer for those loads is an asset owner in MISO. They're their own node. They're operating independently in a federally regulated market where they could contract with IPPs, other organizations that are competitive. So yes, they're outside of the system, outside of Tier 1.
Thank you. So if a new megaload customer took service under rate 531, and if, as you suggested, most of their demand went into Tier 2 and 3, then a relatively small share of the transmission cost that their activity is driving would be allocated to them. Would you agree with that?
For the generation, it's going to be most likely outside of NIPSCO, so that's not going to be in their rate base. That's going to be external. Existing customers would truly be ring-fenced in that case because it's a separate contract with an IPP and privately done. So if that megaload customer goes away, then they're just on the hook for the 10,000 minimum in Tier 1. And then the transmission charges, depending on location and other factors, are going to be, and who owns the lines and exactly where they are, is going to be allocated to that customer separately. It just won't be through like a rate case. It's going to be through MISO for Tier 3. So they're still going to be paying for their transmission, and that could be a very high cost depending on where they're located. They're not, and if NIPSCO owns that transmission, they're going to be getting a piece of it.
So if NIPSCO builds new transmission to support the new megaload customer's activity, the megaload customer would pay only a share of the cost.
Right, and that's going to be, my understanding is that would be determined by MISO because MISO is going to operate, NIPSCO is going to own the lines, but MISO is going to operate it and allocate it. And if it's a 500 megawatt data center, I'm assuming they're going to be using a lot of the capacity on that line, and they'd be paying for the majority of that line and those upgrades.
Okay. Thank you. That's all my questions. Oh, and Your Honor, I'd like to move for admission of Exhibit CAC CX25.
Okay, I will pause for a moment. Anyone with objections to CAC CX25?
I have a point of clarification that may be moot. We filed rate 631 that is materially the same, and it's effective today. I have no objection to admission of this, but I just wanted to note that on the record.
Okay, thank you. Intervenor CAC CX25 is admitted into this cause, into the record. Any further cross for Mr. O'Connell? Then Mr. Friedman, redirect.
One final question. Were you attempting through your testimony to distinguish three different alternatives to provide a data center load? House Enrolled Act 1007. Number two, creation of a large load tariff offering as I&M did in 46097. And then Tier 3 of 531 is the third option.
Yes, and thank you for that. I think the core of this testimony is to kind of get at the pretense for creating this organization. It's new. We're doing it for speed to market. We're doing it to protect people and ring fence. We're doing it for financial stability. I think there's what was discussed earlier, that there is an opportunity to make a lot of money here and to avoid the more onerous pieces of regulation while getting the benefits of the ones that help you, like eminent domain. So in saying this, I just wanted to show that there's written down right here, there's options with some minor, a few bullet points and additions and protections could be used. And again, in Tier 3, that would be ring fenced. It's totally outside the system, so it's safe. If they did this 2 years ago or with previous rate cases, then customers would have certainty on what they need to do. There'd have to be a new cost of study, but just to show that there's plenty of other alternatives that would get at the reasons for why GenCo is being created. This isn't the only option.
Thank you, Your Honor.
Okay. All right, thank you very much, Mr. O'Connell. You're excused from the witness bench.
Thank you, Your Honor.
We'll go off the record. So while we're off the record, it's about 5 o'clock. We're due for a break. Should we do a 15-minute break and then call Mr. Thomas, or?
Whatever is the pleasure, but yes.
What do you,
Questioning of Ted will be brief. I think he's got a flight. So, I mean, if we can.
yeah, you need to go. That's, okay. Do you need a break, Linda? You want to just get it under, yeah. Okay, so this is kind of unfair, but Ms. Washburn, so it'll be Mr. Friedman crossing Mr. Thomas. Do you have an idea, Mr. Friedman, of how long you might need, or?
It'll be fairly short. I'm looking at strictly items that he's recommended for addition to the settlement versus what is in 46097.
Okay, okay. And have the parties talked about post-hearing briefing schedules?
No, Your Honor.
Okay. All right, if we're ready, we'll go back on the record. Okay, we're back on the record. Ms. Washburn?
Thank you, Your Honor. At this time, CAC would call its witness, Ted Thomas.
All right, Mr. Thomas, if you could please raise your right hand. Do you swear or affirm that the testimony you will provide today will be the truth, the whole truth, and nothing but the truth? Thank you very much. You may be seated. Ms. Washburn.
Thank you, Your Honor. Good afternoon, Mr. Thomas. Thanks for sticking with us here.
Good afternoon. Yeah. Okay. Hello.
Thank you. You have what's been marked before you as CAC Exhibit 1. your direct testimony, the court reporter copy is right there, which is your direct public testimony, CAC Exhibit 1C, which is the green paper, the confidential pages of your direct testimony, and then CAC Exhibit 2, which is your testimony in opposition to the settlement. Do you see that?
Yes.
Great. And if I were to ask you the same questions as are presented in the testimony today, would your answers be the same?
Yes, they would be.
And do you adopt this CAC Exhibit 1, 1C, and 2 as your sworn testimony?
Yes.
Thank you. Your Honor, the witness is tendered for cross.
Okay. Mr. Friedman has crossed. Does anyone else have cross on this side? No. Okay, Mr. Friedman, you may proceed.
Thank you, Your Honor. Good afternoon, Mr. Thomas. We've placed at the witness stand a document marked for identification as CX8, LaPorte County CX8. Ask if you recognize this document.
Yes, I do.
And did you have some role or participation in preparing this particular document, specifically the areas referenced in the middle of the document pertaining to the settlement agreement in 46097?
I did not, but I'm familiar with the document.
Okay. And you've read the document fully and are familiar with the terms contained therein, is that correct?
Yes, that's correct.
And you're testifying on behalf of Citizens Action Coalition, which is the sponsor, the author, and the provider of this particular document. Is that correct?
That's correct.
All right. Now, you've made some recommendations in your testimony, the opposition to settlement agreement testimony, that you thought could, again, you've opined against the settlement, you've opined certainly against the creation of GenCo, but you said on page 25 of your testimony, there are certain conditions that could be imposed that could make the agreement more acceptable. Is that correct?
Yes, that's correct.
Let me ask you about some of the conditions that were imposed in 46097, because as I look at your recommendations, while there is reference to large early termination fee, I don't see any kind of recommendation about normal minimum monthly bills. Is that correct?
That's correct.
Okay. And in fact, that was a key part of the settlement agreement in 46097, wasn't it?
Yes, it was.
And just so that we're clear, the settlement agreement in 46097 provided a path for data center development, and it was approved by this commission, and it was a collaborative effort between CAC, OUCC, I&M, and any other intervener. Is that correct?
Yes, it was.
Approved unanimously by this commission, correct?
Yes.
Let me have you go to the middle part of the document that pertains to the settlement agreement, because I understood, and I've got to hand it to those crafting this, because I know it took a great deal of work, didn't it, to come to settlement in 46097.
Yes.
And with that settlement in place, in fact, data center development has occurred, for instance, in New Carlisle, Indiana. Is that right?
I'm not familiar with that.
Are you aware that the Amazon Center is now fully abreast in terms of construction?
I'm vaguely familiar with that.
Okay. Did you happen to see the New York Times article that was done just about a week ago on the data center development in New Carlisle?
Yes, I'm familiar with that.
Okay. And part of that agreement, which allowed I&M to move forward and to assist Amazon with data center development, provided various key conditions for large load customers, did it not?
Yes.
Okay. Among those was large minimum monthly bills. Is that correct?
Yes.
Okay. And that wasn't necessarily included in your recommendation, was it?
It was not.
Okay. You also, if you look at the settlement agreement, it provided strict collateral requirements. Isn't that right?
Yes.
Again, I don't see that in the recommendations that you made here at page 25. Is that correct?
That's correct.
Okay. I think there was some discussion about long-term contracts being a critical part of the agreement in 46097. Is that right?
Yes, that's correct. Okay. And then I would relate that issue to the minimum monthly bill, because the term of the contract will control the minimum monthly bill.
As part of that agreement, there was also Microsoft, Google, and Amazon all agreed to contribute to low-income efficiency programs. Is that correct?
Yes,
And that wasn't necessarily in your recommendations either.
it was not.
So the settlement agreement that was crafted by all the parties and approved by this commission contains detailed provisions both, and it's provided in the document I've given you. It provides a summary of the minimum monthly bill. Would you go to that portion of the document? Because I think it may help the commission and staff to see the detailed provisions that were contained in the settlement agreement.
I'm at that page.
It's past the.
I'm there.
Are you? Good. And you see that section that talks about minimum monthly bill.
Yes.
Okay. The settlement agreement also talks at the next page about exit fee and contract flexibility. Is that correct?
Yes.
The document that your organization provided also details extensively the exit fee that's required. Is that correct?
Yes.
And other settlement provisions in 46097, which has obviously been a clear path to data center development. And are you aware of any other data centers going up, for instance, in Granger, Indiana, as a result of this?
I'm not.
Okay. This particular provision indicates there's transparency, grid-enhancing technology, clean transition tariff, and cost allocation. They're all included in the settlement. Is that correct?
Yes.
Okay. They were not included in your recommendations, were they, at page 25 on trying to improve this agreement, correct?
We're not.
Okay. Your Honor, I'm going to move to admit cross-examination, LaPorte County cross-examination Exhibit 8 at this time.
I will pause to allow for any objections. Intervenor LaPorte County cross-examination 8. Did I cut someone off? Okay. Is admitted into the record of this cause.
Thank you. No further questions of Mr. Thomas.
Okay. Thank you.
Your Honor, I would respectfully request the opportunity to ask 2 questions that I expect to take no more than 30 seconds.
Please proceed.
Mr. Thomas, I know Mr. Friedman referred to this repeatedly as a settlement that INM reached. Is it your understanding that was a settlement agreement that ultimately was reached and approved by the Commission?
Yes.
And what is your understanding of the precedential value of settlements in Indiana?
I know they're not legally binding.
Do you have any understanding of the precedential value in terms of our settlement agreements precedent on which the IURC would be required to lean upon as legal precedent in a future proceeding?
It's my understanding that they're not.
Thank you. Nothing further.
Any further cross-examination for Mr. Thomas? Hearing none, Ms. Washburn, redirect.
Thank you. Just briefly, Mr. Thomas, Mr. Friedman walked through some various terms that were in the 46097 settlement that were not included in the GenCo proposal or the settlement. Can you explain why some of the items Mr. Friedman discussed are not in your proposal?
I would divide, if you took the terms that I recommend and the terms in the settlement, I would divide them into 2 buckets. One would be a bucket that I would expect because the interest of the existing NIPSCO customers and the company are aligned, that the parties would negotiate because they're adverse, like these contract terms. They're in the settlement, which is a settlement of a negotiated contract. And we have a separate bucket that would be policy, that should be generally applicable in all contracts, that I would not expect those parties to negotiate. And the chief example of that would be if you had a very high minimum bill that matched the contract term such that the asset was fully paid for at the end of the contract, but there was remaining useful life in the asset, who gets that value would be a very big question. And I would not expect an adverse data center and their electric supplier, or they're adverse in terms of negotiation, to take that value and distribute it to anybody other than themselves. They're not going to use that as a cushion against possible adverse effects to other customers. The data center will have enormous leverage at the end of their contract, and they might want to capture that value for themselves as a condition on extending the contract. Otherwise, if the data center leaves and NIPSCO has an asset, or GenCo has an asset that is fully depreciated, well, then they could turn around and sell that asset back to NIPSCO and get a second recovery on the same asset, which would be an unjustifiable windfall. And in fact, if you take anybody's reasonable projections of what their earnings would be, which will be an issue in each contract, that would blow that out of the water, because it would be a very large recovery, because they would be recovering twice for the same asset, which is why I have a that says if NIPSCO buys an asset from GenCo, that it should be at a bid price, or which is ever lower between the unrecovered plant balance. That way, the other NIPSCO customers can capture some of that value. They'll never negotiate that in their term. Then the reverse is also true if you have a fire sale situation where you have remaining generation in search of a load because the contract expires and you have a fire sale. Somebody's going to capture the value. Now, with a fire sale, there's also risk. But if somebody can buy generation very cheaply, some investor that's probably knows the situation up close because they're around all of this stuff, well, then they could capture the value of the fire sale, even though if there is a fire sale, the kind of financial distress that would impact NIPSCO's credit rating to the detriment of its customers is probably, that risk has probably been realized. You have a fire sale caught by other value captured by the purchaser at the fire sale, which is why I recommend a right of first refusal for NIPSCO so they can match that price. That, again, is not a term that the megaload customer that will come up in the PPA. They're not going to hand value to other people. But the stuff on the list that I talked with Mr. Friedman about, the length of the contract, we should give the negotiation the first cut on that. I don't think we should have a standard contract. And those kinds, that's, to me, the kind of litigation that should happen contract by contract or the contract-specific terms. But in order to protect the existing NIPSCO customers, these broader policy terms should be imposed beforehand. Because if you come in with a negotiation, they're not going to include those terms. Then CAC will intervene and say you should include those terms. And if the commission reforms the contract and adds that term, you've disrupted their contract. It's better to have that as a mandated term on the front end, and with the commission's guidance as to what's in the public interest, then that let them negotiate those contract terms.
Thank you. Appreciate it. No further redirect. Thanks.
Okay, thank you. And I understand Mr. Thomas identified intervener CAC Exhibits 1, 1C, and 2, but I'm not sure those were offered into the record.
I'm so sorry. Yes.
And if you'd like to do that at that time, are there any objections? I'll pause. Hearing none, intervener CAC Exhibits 1, 1C, and 2 are admitted into this cause.
Thank you, Your Honor.
Okay, thank you very much, Mr. Thomas. Safe travels. You're excused from the witness stand.
Thank you. And those are your copies.
Go off the record.
No, Your Honor, I don't think so. I know that we would like to request a transcript, as I imagine other parties might.
So there'd be 2 rounds instead of 3. No, all parties would have to have a second reply. So
So we're looking at a transcript July 16th. 2 weeks from that would be July 30th. That could be a date for a proposed order. And then we could do a week from that. That would be August 6th for any responses. Yeah, I'm okay with that. Well, if you're okay with the 28th and the 6th, I mean, that just gives us a couple more days. I think that's.
Your Honor, we would prefer the 8th if possible.
Okay. Yeah, so we're looking at,
intervener
if we go with the 8th, would you then reserve the 30th for your due date? Okay. So we're looking at July 30th, which is 2 weeks from the transcript for the proposed orders, and August 8th for exceptions, and then a reply 1 week after August 8th?
Your Honor.
Oh, okay. Yeah. That sounds good.
Your Honor, the only hesitation I have is that we had another case settle right before the hearing, and so all of our schedules have been pushed. The Duke Cayuga case is now scheduled for August the 1st. So that'll be pretty tough, navigating all of that. Could we have just like 1 minute and to, okay.
Yeah.
Thanks.
All set, Linda? All right, we're back on the record. We discussed a post-hearing briefing schedule. I believe we've come to an agreement. Mr. Likens?
Yes, Your Honor. Thank you for the time. Thank you for staying late today. What we are proposing is that the settling parties' initial post-hearing filings would be submitted on July the 18th, responsive pleadings from the non-settling parties on August the 8th, and any reply, if necessary, by the settling parties by August the 15th. And that would complete the post-hearing filing schedule.
Thank you. And we will endeavor to get an order out in September if possible. Thanks, everyone, for your time today. Appreciate your patience very much, and I hope you have a good rest of your day. We're adjourned. Thank you.